My scenery is not well. Kindly pass out the matter for the day. Immediately after 3 weeks. Item 12.
When do you want?
So after 3 weeks. He's not well.
19 bottom for 2 weeks. Quit. Needed to be fixed. Or a new or India week commencing from 12th of February. Okay. Only date to be fixed by the okay. Obliged.
May I please, your lordship, engage counsel where is taking another court. Kindly pass over the matter for time.
Just
Lordship asked for a report in respect of the proceeding, Lordship, but the conclusive report was not given, Lordship. Some FIR copy, Gaura certificate has been sent, Lordship. I have telephonically instructed them to give it.
no, what is this? What is the information given by the Gambra?
That he is missing since last 5 years. Lordship.
That is not the case. What we want is what is the police report regarding the missing information.
Yes.
Right?
Yes, Lordship.
To see the consequences, a person has been declared as a foreigner.
Yes.
File a writ petition.
Yes.
Then he is found missing.
Yes.
That report has to be, the SP Bugdar and all has to be, Home Department has to exercise on it,
Yes, Lordship.
right?
Yes, Lordship.
So tell us when you're able to give the,
Which time may be allowed, Lordship?
give us a date. So your authorities also worked on it.
Right, 30th February. Lordship. Report to Hana.
Heard Mr. Yazmi, Council observing for petition. And Mr. G. Sharma, Standing Council, Home Department, Assam. Mr. Sharma, Standing Council, Home Department, submitted. That. He is yet to receive the conclusive status report. Conclusive up-to-date status report. About the petitioner. Who, after filing this writ petition, challenging the opinion dated 06/07/2017 of the landed member Fairness Tribunal number 9 Nagaon in FT case number 98/2015. Declaring him to be a foreigner. Declaring her to be a foreigner. Is missing for about last 5 years. As such, Mr. Sharma is seeking some more time to submit that report. Submit the report in that regard from the authority concerned. Prayer allowed. List on 13/02/2024 for relevant report as sought for by reporter.
Obliged, madam.
Yes, whether the petitioner herein has been released.
Yes, Lordship, and they inquired about the petitioner, they find in their home, Lordship, and intimated about the case pending before the High Court, Lordship.
Yesterday, I have received a telephonic call, my lord, stating that he is on his residence, my lord, and now he has been suffering from paralysis, my lord. He regularly attend the concerned police, my lord. Concerned police station.
Heard Mr. K. R. Pandit, counsel appearing for the petitioner. And Mr. Z. Sharma, standing counsel, Home Department, Assam, for the respondent number 2, 5, and 7. Also heard Mr. P. Sharma, additional senior government advocate, Assam, for the respondent number 6. This writ petition filed by the petitioner on 10/09/2019 is against is the order, impugn order and opinion dated 09/07/2018 passed by the learned member of Foreigner Tribunal, Desk Capital Roman 2, Lakhimpur, not Lakhimpur, in LFT Desk Capital Roman 2, case number 616/2015. In a reference being made by the Superintendent Police Border, Lakhimpur, not Lakhimpur, whereby after hearing him and considering the evidence adduced and considering the evidence after hearing and considering the evidence adduced by him, and the other parties appoint a petitioner to be a foreigner under the Foreigners Act 1946, who had illegally entered into territory of India within bracket Assam on or after 25/03/1971. The petitioner also made the member of Foreigners Tribunal, that's capital Mantu Lakhimpur, who passed the impugned opinion on 09/07/2018 as a party respondent number 8 in the present proceeding. And we are of the opinion that it is not a necessary party for proper adjudication of this petition. Accordingly, the respondent number 8 be deleted from the cost type. Registry shall accordingly to the need. Pursuant to our earlier order dated 2012-2023, Mr. Z. Sharma, Standing Counsel, Home Department, on instruction of the Superintendent Police Border, Lakhimpur, dated 04/01/2024, apprised the court that the petitioner, after his release from detention camp, his food has been found in his own residence. This notice returnable by edits. Accordingly, the petitioner shall not leave already. Call for the records to record or to electric case number such and such from the office of the London Foreigners Tribunal to law. The petitioner shall not leave the jurisdiction of the Superintendent Police Border, Lakhimpur, not Lakhimpur, without obtaining prior written permission. List according.
Oblige.
Copy of the communication of the SP within bracket B, Lakhimpur, not Lakhimpur, dated 04/01/2026, placed before the court. The case is not- Another photocopy.
Make your lordship.
Yes, ma'am.
In this case, your lordship directed the unit to file the status report. Ma'am.
You have any information, Mr. Sharma?
Yes, Lord.
Please.
Your opinion.
What's it? Go correr, go para el forensic report also the lordships. Next is this 3.
Forensic opinion.
Then
Lordships,
They are not authorized, no? What control they have?
Third MS and second under counsel for the petitioner. And Mr. P. Sharma, Learned Additional Senior Government of Assam for the respondent numbers 1, 2, and 3. Pursuant to the order dated 21/12/2023. Mr. Sharma, Learned Additional Senior Government Advocate, placed the written submission of the Superintendent of Police, Kokrajhar, Assam, dated 12/01/2024. Pertaining to the issues involved in this writ petition. Issue notice returnable by 6 weeks. As Mr. P. Sharma, standing counsel, additional senior government advocate, appeared and received notice on behalf of the respondent numbers, official respondent numbers 1, 2, 3. No formal notice need to be issued. Petitioner shall serve requisite extra copies to Mr. Sharma, additional senior of Assam, along with the annexes of the within 2 days from today, if not served earlier. Obtaining necessary acknowledgement, may not serve earlier. Petitioner shall take steps for service of notice on the respondent number 4 by register post OTD, providing its characters for the district to take with the post system to respond today. The respondent numbers 1, 2, and 3 shall file their affidavit in this matter as per the report submitted before the Superintendent of Police, Kokrajhar, respondent number 4. Dated 12/01/2024, placed before the court today. You file your affidavit. Such affidavit shall be filed within the next 4 weeks. Placed accordingly.
I'm like,
You can take back the report and submit. Or you have a copy?
yes, I have copy,
You have a
extra copy. Lordship, forensic report also is there.
that is there. Do you have the forensic?
Yes, there is,
File your affidavit.
yes.
May I please, your lordship? Lordship, last occasion LCR was called for.
Yes, we have the records. Please make your submission. Okay, where is your written statement?
Annexer F, lordship.
Annexer F. Okay,
Page number 20.
kindly read.
That there is no cause of action,
You start from para 3.
that the opposite party is a permanent resident of village Sampapura Gaon, PO Sampapura Bazar, PS Soygaon in the district of Kamrup, Assam. That paragraph 4, that the opposite party is a permanently residing at village Sampapura Gaon, PO Sampapura Bazar, PS Soygaon, Goroimari Revenue Circle, Moza Goroimari in the district Kamrup, Assam. I issued a certificate dated 10/1/2011 in favor of the opposite party, showing that the opposite party is a citizen of village Sampapura Gaon. And that the opposite party father was born in her paternal village, Notun Deosar, P.O. Paneri, P.S. Boko, Moza Bongaigaon, Kamrup, Assam, and her father was late Rajab Ali. That the name of the opposite party father, namely late Rajab Ali, grandfather late Ronjo Seth, and grandmother late Myron Nasha, name have been appeared in the voter list of 1966 at village Jorsimolu Gosputa, block 54, Moza, Pub Somaria, under 56 number Soigaon, LSC in the district of Kamrup, Assam. 7, that the name of the grandfather late Ronjo Seth, grandmother late Myron Nasha, father late Rajab Ali at the opposite party appears in the voter list in the year 1970, constituency of village Jorsimolu Gosputa, LSC 56 number Soigaon, Moza 56 number Soigaon, Moza Pub Somaria district Kamrup. That the name of the opposite party also appeared in the voter list of 1993 along with her father, mother, and 2 brothers, where the father's name of the opposite party appears as Rajab Ali, where the mother name of Sarbun Nesha, where their brothers are Jinnat Ali and Sorko Ali. Number 9, that the opposite party is having PAN card. That as the opposite party is born and brought up in Assam, NFC is liable to produce the above voter list for the year 1966, 1970, 1993, and a certificate issued by the government of Gaonbura in her identification. Hence, she is not foreigners and she has never entered into Assam 25/3/1971 as alleged by the Honorable Foreigners Tribunal and the Foreigners Act 1946.
Okay, now, what are the exhibits that you have made before the tribunal?
Gaonbura certificate as Exhibit A. Then one more Gaonbura certificate.
Just tell us which annexer?
Exhibit
Yes.
Annexer A, Lordship, it's Gaonbura certificate
Annexer A.
A.
Okay.
Then again, Annexer B, another Gaonbura certificate.
Now, whether the person who issued this certificate has adduced any evidence to prove this certificate?
Lordship, come to page number 39. Deposition, there is a deposition, Lordship of Gaonbura.
Yes.
Moi Deure
Deusor.
Deusare Aru Sampapura Gaon Gaonburar Pramanpatra.
Then
No, Lordship, it's not.
probably not, because only 2 witnesses were examined,
Yes, Lordship, yes.
right? The proceeding and her projected brother.
Brother.
But even if you read this, just read it for yourself and tell us whether this indicates anything that you are citizen of India by that means. Kindly read. Praman Patra diya hoy. You are relying on this, right? Just read case 11.
Which page, Lordship?
11.
Page 11.
11. প্ৰমাণপত্ৰ দিয়া হয় যে মিছ ৰহিমা খাতুন পিতা
Name of father is not there, right?
স্বামী,
Swami
yes,
Omar Ali.
yes, Lordship.
Gaon, Sampupara Gaon.
চম্পুপুৰা গাঁও,
Post office, Sampupura Bazar, Moja Goroimari, Thana Soigao, Zila Kamrup Baham, right? And read the contents. Now,
এওঁ চম্পপুৰা গাঁৱৰ
Sampupura Gaon, Manu Hoy.
চম্পপুৰা পথৰ মানুহ হয়। মই জনা মতে এওঁৰ স্বভাৱ চৰিত্ৰ ভাল। এওঁৰ নিজৰ পিতা স্বামী
Peter Nai, Swami,
Swami.
because tick mark is above Swami, right?
এওঁৰ নিজৰ স্বামীৰ
Swami Namot.
চম্পপুৰা পথাৰ ইমান 2019 চনৰ ভোটৰ তালিকাত নাম থকা দেখা যায়।
Hmm.
যথাক্ৰমিক নম্বৰ 1015 ঘৰ নং 302 খণ্ড নং 55 89
49.
49 ছয়গাঁও সমষ্টি। গতিকে মই এওঁৰ জীৱনৰ উন্নত ভৱিষ্যত মংগল কামনা কৰোঁ।
Now here it is raised to wife of Omar Ali,
উমৰ আলী,
resident of Sampapura village. Only that much. Linkage with the projected father is not available here. Even if, let us assume that the person concerned whether adduce evidence or not. This particular certificate issued by the village headman doesn't indicate anything, the linkage of you, the prosody and the father of the prosody. Next, which we have related.
but Lordship, we have the voter list.
Hmm.
Annexer C.
Hmm.
Voter list of 1966.
Now, there is another certificate that you have adduced,
Yes.
page 13. Now, this has been issued by the village headman of Paneri. Have you seen?
Yes, Lord.
Who has issued this? Which Gambura have issued this?
বনগাঁও, ছয়গাঁও road.
Look at the top. One Hujjo Kolita.
সূৰ্য কলিতা,
What is the village? Paneri.
গাঁও পানেৰী, মৌজা বনগাঁও, ৰাজচক্ৰ ছয়গাঁও।
Now come to the signature. Hujjo Kolita Gambura down below.
Yes, বনগাঁও পানেৰী।
No, Gambura, Korhala, Bahjani, and Paneri. Now come to page number 21. Para 5. You have stated
বাছ
that you are resident of
নতুন দেওচৰ
Notun Deosor. Your village is Notun Deokhor.
Yes, PO
Post
Paneri.
office is Paneri.
Yes,
Village is Notun Deosor.
village not.
And this village headman doesn't belong to Notun Deosor. He belongs to Paneri. And if you see the villages down below, Korsala, Bahajani and Paneri, nothing to do with Notun Deosor. Above that, there is no date on which it was issued. Thirdly, it has a national emblem. Fourthly, the person who gave this certificate did not adduce any evidence. Right? Okay. Next is the voter list. Yes. What do you want to show from here?
Yes, Lordship, Annexure C.
Hmm.
Her grandfather's name is there, Lordship, Rongo Sheikh,
Hmm.
and her father's name is also there, Raja Bali.
Village.
Jur Himolu Gaon, Gosputa.
Jor Himolu, Gosputa. Block number 54. Moja Pub Somoria, District Kamrup. Okay. Then
Then Lordship, another voter list of 1970. Here also her grandfather and her father's name is there. From Jorsimolu Gosputa.
now please come to page 21 again. Read para 5.
That the opposite party father was born in her paternal village, Notun Deosor, PO Paneri, PS Boko, Moja Bangagaon, Kamrup, Assam, and her father was late Raja Bali.
But this village is Jor Simolu Gosputa.
Yes,
There are two different villages. Next. After 1970.
yes, Lordship. Here is another voter list of 1993. Here, her name is there along with her father, Raja Bali and Rohima Khatun, under village Dhalsor Deosor. Dhalasor Deosor.
So what happened from 1970 to 1993? What happened from 1970 to 1933? Whether the petitioner studied anything?
No, Lordship.
Okay. Let us read their evidence. Let us read the evidence of the. Let us go to the cross of the DW1. It starts at page 37. Candidate.
মোৰ জন্ম নতুন দেওচৰ গাঁৱত হৈছিল। জন্মৰ মোৰ ককা দেউতাৰ নাম
মোৰ চনটো নাজানো।
চনটো নাজানো। মোৰ ককা দেউতাৰ নাম ৰংগু শ্বেখ আৰু আইতাৰ নাম ময়ৰুন নেছা। মোৰ বয়স 10-12 বছৰ থাকোতে মোৰ ককা দেউতা আৰু আইতাৰ মৃত্যু হৈছিল। মোৰ মাৰ নাম সৰগুন নেছা, মা জীয়াই আছে। প্ৰায় 35 বছৰ আগতে মোৰ দেউতাৰ মৃত্যু হৈছিল। 1961 চনত দেউতাৰ নাম প্ৰথমে নতুন দেওচৰ গাঁৱত ভোটৰ তালিকাত উঠিছিল 1961 চনত সেই ভোটৰ তালিকাত দেউতাৰ লগত মোৰ মা মোৰ নিজৰ নাম আৰু দুজন ভাইৰ নাম
ভাইৰ নাম
উল্লেখ আছে
হুম
1993 চনত নতুন দেওচৰ গাঁৱত মোৰ ভোটৰ তালিকাত মোৰ উঠিছিল প্ৰথমবাৰৰ বাবে উক্ত গোচৰ আদালতত মোৰ উক্ত ভোটৰ তালিকাত মোৰ নামো উল্লেখ আছে
হুম
মোৰ দেউতাৰ জন্ম দেওচৰ গাঁৱত হৈছিল দেওচৰ গাঁৱৰ বাহিৰে কোনো অন্য কোনো ঠাইতে গাঁৱতে দেউতাই বসবাস কৰা নাছিল
হুম
মোৰ বিয়া
কেতিয়া হৈছিল
কেতিয়া হৈছিল মই নাজানো বিয়াৰ সময়ত মোৰ 18 বছৰ আছিল স্বামীৰ নাম উমৰ আলী স্বামীৰ লগতে চাম্পুপুৰা গাঁৱৰ ভোটৰ তালিকাত মোৰ নাম আছে কোন চনত আছে মই নাজানো 1961 আৰু 1970 চনৰ ভোটৰ তালিকাত মোৰ দেউতাৰ লগতে মোৰ মাৰ নামো দেওচৰ গাঁৱত উল্লেখ আছে
হুম
মই দেওচৰ আৰু চম্পপুৰা গাঁৱৰ গাঁওবুঢ়াৰ প্ৰমাণপত্ৰ দাখিল দিছো চম্পপুৰা গাঁৱৰ গাঁওবুঢ়াৰ নাম জংচুৰ আৰু দেওচৰ গাঁৱৰ গাঁওবুঢ়াৰ নাম নাজানো গাঁওবুঢ়াৰ প্ৰমাণপত্ৰ মই নিজে আনা নাই মোৰ ভাই সৰ্বেশ আলীয়ে আনিছে উক্ত প্ৰমাণপত্ৰ দুখন কথা মই জনা নাছিলো
Now, please come to page number 22.
Yes, Lordship.
Read para 8.
That the name of the opposite party also appeared in the voter list of 1993 along with her father, mother and two brothers, where the father's name of the opposite party appears as Rajab Ali, where the mother name of Sorbun Nesha, where their brothers are Jinnat Ali and Sorko Ali.
Now, just now you have read at page 39. What is the name of your brother?
Sorbesh Ali.
Sorbesh Ali. And what you have stated in your written statement? Sorko Ali,
Sorko Ali.
right? Okay. Now, come to
Here,
the evidence of your projected brother at page 34.
আজি মোৰ
Honey,
ভনী ৰহিমা খাতুন নেছাৰ সাক্ষী খাতুনৰ ওচৰত সাক্ষী হিচাপে মাতিছে আহিছো বিপৰীত পক্ষৰ বৰ্তমান বয়স 45 বছৰ 24 বছৰ বিপৰীত পক্ষৰ বিয়া হৈছিল তেওঁৰ স্বামীৰ ঘৰ চম্পপুৰা গাঁৱত স্বামীৰ নাম উমৰ আলী বিয়াৰ সময়ত ৰহিমা খাতুনৰ বয়স 18 বছৰ আছিল বিপৰীত পক্ষৰ নাম প্ৰথম ভোটৰ তালিকাত কোন চনত উঠিছিল মোৰ মনত নাই 1961 চনত 66 চনত জোৰচমলু গাঁৱৰ ভোটৰ তালিকাত মোৰ দেউতাৰ নাম উল্লেখ আছে উক্ত ভোটৰ তালিকাত মোৰ ককা দেউতা আইতা আৰু দেউতাৰ নাম উল্লেখ আছে
That's 61, not 66. You are correct.
1960,
1995
1995, 96
son
চনত দেউতাৰ মৃত্যু হৈছিল। দেউতাৰ জন্ম কোন চনত হৈছিল আৰু কোন ঠাইত হৈছিল মই নাজানো। দেউতা জোৰচিমলু গাঁৱৰ পৰা নতুন দেওচৰ গাঁৱলৈ কেতিয়া উঠি গৈছিল মই নাজানো। মই ভোটৰ আইডেন্টিটি কাৰ্ড আনিছো আৰু মোৰ লিখিত সাক্ষীৰ লগত জমা দিছো। 1993 চনত বিপৰীত পক্ষৰ বিয়া হৈছিল নে নাই মই নাজানো। উক্ত 1993 চনৰ ভোটৰ তালিকাত মোৰ আৰু
আৰু
বিপৰীত পক্ষৰ নাম একেলগে আহে
আছে।
আছে। 1993 চনত দেউতাৰ বয়স কিমান আছিল মনত নাই। 1961 চনৰ ভোটৰ তালিকাত দেউতাৰ বয়স কিমান আছিল মই নাজানো। 10-12 বছৰ মানত থাকোতে নতুন দেওচৰ গাঁৱত মোৰ ককা দেউতা আৰু আইতাৰ মৃত্যু হৈছিল। জোৰচিমলু গাঁৱৰ পৰা নতুন দেওচৰ গাঁৱলৈ অহাৰ পিছত মোৰ ককা দেউতা আৰু আইতাৰ নাম দেওচৰ গাঁৱৰ ভোটৰ তালিকাত উঠিছিল নে
উঠিছিল
নে
চনত নাজানো।
নাজানো। মোৰ আৰু
চনটো নাজানো।
চনটো নাজানো। মোৰ
ভোটৰ তালিকাত উঠিছিল চনটো নাজানো।
মোৰ আৰু বিপৰীত পক্ষৰ জন্ম নতুন দেওচৰ গাঁৱত হৈছিল।
Now, from the reading of the written statement of the proceeding, it is very clear that there was no mention regarding shifting of the projected father of the petitioner from Deosar village to Deosar village,
Deosar.
right? From Jorhimolu
Jorhimolu.
village. The proceeding herself stated that her father, excepting Deosar village, never resided in any other village. Both are contradicted. The voter list of 1966 and 1970 of her projected father relates to Jorhimolu village. It has to be two different parts. So, as you know, with regard to the Foreigners Act, in particular Section 9, it has to be a conclusive proof. Now, do you think that the evidence adduced by the petitioner to prove her nationality, these evidence which have been placed before the tribunal, are conclusive proof to prove her nationality as an Indian citizen or born to a parent belonging to an Indian citizen? See, basically, we cannot go beyond the evidence that is before us, right? What do you say? Yes, we can understand that you can argue for your client, but as a court officer, what is your suggestion or what is your submission? Whether the proceeding could prove conclusively to prove her linkage with Rajav Ali, whose name figured during 1966 and 1971 at village Jorhimolu is the same and one person whose name figured in the voter list of 1993 along with her. Whether she could prove. Because father has to be exist during that period or her grandparents, right? Whatever. That's right. See, we are also human beings. We have also emotions. But we have taken oath in the name of the Constitution of India. We have to abide by the laws. We cannot go beyond that. Right?
But as she has mentioned her grandparents' name in the deposition.
Might be, but of which village? That village relates to
Hospital.
Dorsimulu.
Yes.
And from the written statement, you have seen there is nothing in the written statement that at a certain point of time,
Shifting.
when they resided at village Dorsimulu, their names in the figured in the voter list of 1966 and 1970. See, basically, these knowledge are only with the proceeding, nothing else. Nobody else will have that knowledge. Neither the concerned lawyer nor any other else, because it relates to the proceeding herself or himself. So,
After the court lordship.
no, definitely you have tried your best, whatever the evidence is there before us, you have tried to place. You have just indicated. Yes, Mr. Sharma or Mr. Payang, you will appear.
My lord, your lordship has already pointed out, and
No, this matter earlier,
yes,
CPR and police,
yes, yes,
so you
my
will
lord,
know about
we
it.
have
I
argued a
already
lot.
called for the record.
Yes. In this case, your lordship may, will find two sets of documents, first 19, prior to 70 and after 70. So prior to 70, this all belongs to George Shimolu.
And there is no such
Gospita.
continuity
Yes.
after 1970 till 1993.
So after 70, there is no documents of George Shimolu Gospita. And 1993, in a different village.
It's a Deusar village.
Yes. And the my lord statement, as your lordship has, my learned friend has read out, the daughter, the proceedee herself say, our father never resided in any other place except this Deusar village. So it means our father was never in Jursimolu Gosputa. So the 71 and 61 and 70 voter list is not of our father. And that is, there is no evidence to that effect also, that it is of our father. They have brought this voter list only and exhibited, and there is no evidence to that effect that it is actually belong to the father of the petitioner. So cross part DW1 has demolished the entire case, my lord. Here it is, she herself is admitted all this fact, that her father was never lived in any other place. In fact, she has studied in 1961 দেউতাৰ নাম প্ৰথমে নতুন দেউচৰ গাঁৱৰ ভোটাৰ তালিকাত উঠিছিল, which is not, the record doesn't say, madam. Those he stated, the grandfather and father's name was there in the Notun Deosar village in 1961. No voter list or no documents of any kind, my lord, could be produced by the proceeding before the tribunal. And that is not a case that
Mr. Prem Sharma. You have been looking after these cases, right,
Yes, sir. From government side on.
from the government side.
Yes,
That's why we are asking you.
yes, sir.
There was a central government scheme. And huge amount was public exchequer. Please take your seat. Mr. Pine, take your seat. Huge amount from the public exchequer
Yes.
was spent for a long period of almost 35 years or 40 years in the name of adult education. Right? And particularly in villages, not in the cities or in towns,
Villages.
right? But while we examining these records consistently, what we found, he doesn't know even how to write their names.
That is the matter.
And, only their thumb impression,
That is my word.
right?
Yes.
Whether those schemes were successful,
Sometime my lord, you will say in rural area. Now government provide very.
what about your area?
In my area, my lord.
Successful in Borsala?
Borsala not successful, but some development area better now. I'm going in it.
You have contested election, you know, you have met all your villages people. At least they are aware
They are, my lord, now some government scheme has provided in rural areas, even the various store area also. my lord. Now,
Thing is this, what we found here,
yes,
hardly rarely one or two can put their signatures.
that is my lord.
We found this money went somewhere else,
Maybe, my lord.
or from the public exchequer. That is the difficulty. The records reveals Mr. Payangul able to tell you how many of them can write their own names.
That is my lord.
Maybe.
Now various scheme provided by government also, my lord. But
No, that's true.
Yeah.
In the name of adult education, Government
Yes.
of India, the central
Yes.
government scheme, right?
Scheme.
And throughout India,
yes,
I don't know what happened in the Assam, but definitely
that is
it
some-
was
that
a
one-
joint venture.
and
100% it was not there from
Not-
the
not successful.
central government. It was initially 80-20, then 75-25. Then persons who were been involved in this adult education,
That is my lord.
their services were also regularized as the teachers.
You know,
Now, what kind of education they rendered to these people, we do not know, but we have seen is all our Angutha chap.
that is my lord.
And that is the difficulty. You see, basically, they are not well versed with the things. And that is why everything has changed. Since they are not aware, maybe they are genuine. But because of their
that is-
statements, or because of the evidence, they fail to adduce evidence, we have to consider them in different way. But had they been literate, things would have been different,
That is my lord.
right?
Yes. Now, my lord, government appointed some adult education officer and every.
It was there very much.
Hmm.
But we found that, very sad to say. Of course, how many of them also participated in such schemes, we do
Yes,
not,
yes,
that also we do not know. But otherwise, we found that it's a total failure.
No, now, there is every village, Anganabadi center also established. for
Anganwadi
provided-
centers mostly related to something else.
There is established some adult
But if you
education.
see that children of this lady who is before us, they might be educated to certain extent. But that particular period,
All stream not success, my lord. No, no,
nowadays they are going to school or they are sending to their school only
Yes.
because they can have their food.
that is my, no.
That's how the
Yes, yes,
students are attracted,
Right,
right? But huge numbers of drops out. In the high school level, you will not get anyone.
yes, lord.
Huge dropouts.
Only LP and ME that is provided.
One of my sister is a teacher in
Also.
a particular village school.
Yes,
There, she told me in my last visit to my village, very recently, that up to class 8, she found the female students available in the school. But suddenly there will not be any less number of female students from class 8. Then they used to send the
English medium.
Chokidas and others to their respective villages to find out why they are not coming to the schools. Parents, there are two communities are there. One is the fishing community, other is the religious minority community. If females stop coming to the school because they are already married,
That is the problem.
Right.
Mm.
Mr. Sharma, this is information 100% correct. That's why you're telling you
Yes,
you are
yes, boss.
initiating process of child marriage.
Yes,
Now, because of the teachers staying there, they used to insist that their children should be sent to the school. They used to come
yes, lord.
mostly for the lunch, right?
Only for lunch.
As it is provided in the scheme, they are entitled. By class 10, when they is to appear in the matric examination, test examination, they will drop because by the time they are pregnant.
That is not the problem.
Look at their life. They becomes mother when they're in class 10. It's happening. And I'm telling all of you, frankly,
Yes, yes, yes.
you are the lawyers, these are the things which you should raise. You should make a movement. What will happen to a particular mother who is hardly
15,
15,
15 years.
giving birth at 15? What will happen to the child? Government is bringing out all the schemes and whatever police case. Nothing is helping because the parents cannot afford to keep their children at home. They doesn't have enough of money because large number of children in each family. I can name the village if you, but do not like to make it. But it's happening, Mr. Sharma.
Yes, my lord, that's
I can give you numbers of villages.
yes.
This is the first information for all of you. Similarly, nothing will happen. Schemes will be there. Government will try to do it. But people, if you do not make them aware,
That is
what will happen to a mother who is herself is a child? Forget of giving birth to a child.
That is the problem, man.
These are the reality.
Real things, my lord.
Anyway, back to the case.
That lots of.
So, adult education from this, what we found is futile exercise. Public exchequer went somewhere else.
That is
Yes, Mr. Pai,
Yes.
let us go back to the case.
My lord, here the first issue is the whether the father of the petitioner, whom the petitioner claimed to be father, is a citizen of India or not. That is not proved. Secondly, my lord, the petitioner fails to prove that the projected father, he was there. He is the projected father was there in India prior to 1970. My lord, in absence of that, even though there is a voter list of 1993, where the petitioner is saying, my lord, petitioner and her father's name is appearing together in Notun Baleshwar village. My lord, that is not enough to prove that petitioner is a citizen of India. Apart from that, there is no other documentary evidence. Evidence of DW2, that is the projected brother. He has not brought any evidence to the effect that the father of the petitioner was there in prior to 1970. And the petitioner is a citizen of India on the basis of any record money. Your Lordship has read out this DW1, evidence of DW1. May I read out once again? With comparing the her written statement.
Before you just make, madam,
Yes, sir.
please come to page number 14.
Yes, Lordship.
In the year 1966, what was the age of your projected father?
22.
So birth year is 1944. 66 minus 20. Come to page 16. What is the age of your projected father?
26.
So 1970 minus 26 is again 1944.
Yes.
Now you come to page number 19 or 18, whatever you want. Let us say 80.
50
India 1993, what was the age of your projected fathers?
56.
So what is the birth year?
1392.
1937.
Yes, 90.
If it is 1937 and 1944, 7 years difference.
My lord,
Yes, Mr. Pai wanted to read something,
yes,
please.
no, my lord, that is the issue, my lord, whether this Rajab Ali of 1993 is the same Rajab Ali who was there in 1970 and 66. That fact has not been established.
No, that's what is.
Yes, that is the issue, my lord.
Yes.
Now, my lord, as we have seen, my lord, the old
your seat,
voter list of 66 and 71 are of, my lord, that is a different village, that is called, my lord, Zur Shimolu Gospel. Now we may read, my lord, the evidence of DW1, the proceeding herself. The proceeding herself stated, more deuter, my lord, this is page 37.
More Janmo.
Yes, more Janmo, Notun Deusor Gaunt Huisil. This clearly said her date of birth, birth was taken place at Deusor village, Notun Deusor. Janmor Sontu Nazano. More Koka deuter nam, Rongu Sheikh, Aru, Aiter nam, Moiron Nessa. More Boyok, Do Barobosor Takuti. More Koka deuter Aru, Aiter, Mitru Huisil. More Marnam, Sarvanu Nessa, Ma Jiayase. প্ৰায় 35 বছৰ আগতে মোৰ দেউতাৰ মৃত্যু হৈছিল 1961 চনত দেউতাৰ নাম প্ৰথমে নতুন দেউচৰ গাঁৱৰ ভোটাৰ তালিকাত উঠিছিল This is the statement your lordship may kindly see in 1961 the father's name was appearing
66 or 61.
it may be 66 61 whatever it may be my lord it may be taken as 66 or 61 দেউতাৰ নাম প্ৰথমে নতুন দেউচৰ গাঁৱত ভোটাৰ তালিকাত হৈছিল So there is no voter list of new Notun Deusor village of 1961 or 66 whatsoever it may be. 1964 চনৰ ভোটাৰ তালিকাত দেউতাৰ লগত মোৰ মা মোৰ নিজৰ নাম আৰু মোৰ দুজন ভাইৰ নামো উল্লেখ আছে This is not correct my lord this may be probably 1993 she was supposed to sing 1993 চনত because it cannot be because she was only 45 years in 2019 18 so her date of birth is sometime in 1978 76 so 66 61 her name cannot be appearing in the voter list 1993 চনত নতুন দেউচৰ গাঁৱৰ ভোটাৰ তালিকাত মোৰ নাম উঠিছিল প্ৰথমবাৰৰ বাবে উক্ত ভোটাৰ তালিকাত মোৰ নামো উল্লেখ আছে মোৰ দেউতাৰ জন্ম দেউচৰ গাঁৱতে হৈছিল This is again one affirmative statement মোৰ দেউতাৰ গাঁও জন্ম দেউচৰ গাঁৱতে হৈছিল দেউচৰ গাঁৱৰ বাহিৰে অন্য কোনো গাঁৱতে দেউতাই বসবাস কৰা নাছিল So this is clear that her father was all along in the Deusor village and so the voter list of 66 and 71 are not 61 and 70 cannot be of this her father. So if the voter list of 66 and 71 goes, there is no documents of her father which shows the existence of her father in India prior to 1970. So the basis from which she can claim her lineage minor is itself is not there. Other aspect, the Gambra certificates it produced those are not, in fact, in absence of the evidence of presence of the father prior to 1971, these documents, Gambura certificate and others are not relevant at all. Because she was trying to show that she is the son or daughter of that father, that person who was there in 1971 in some other village. However, my lord, I'd like to rely on because she has produced the evidence of her brother, projected brother. He could not deduce evidence on the basis of any record. He has come and given his oral evidence, and this honorable court has said mere oral evidence is not enough to establish a citizenship of a person unless it is corroborated by the documentary evidence. So there is no case at all, my lord. The tribunal has committed no error while deciding this case, my lord. So other aspects, certiorari jurisdiction, my lord, we may not interfere in the findings of the fact if it is not, my lord, barred by my lord, some particular conditions like non-issuance of notice or no this, my lord, no admissible evidence were admitted. These are not there. These will not even alleged in the writ petition also. And he exhibited on it. It is admitted fact. Exhibited, my lord. Exhibit A is the Gambura certificate, which is not proof. That is the Gambura has not even come to the post. Exhibit B is also a Gambura certificate. It is also not proof. So these documents, though we accept this, my lord, she is trying to bring the relationship linked by these two documents. These documents are not proof. Voter list of 66 of a different village. There is no proof that that person and this person is the same person. 70 is the voter list and 93 voter list. So voter list of 93 and 70, my lord, these are not proof. The link of 70 and 93 is not proof. That has to be proved. That the person whose name is there in 93 is the same person whose name was there in 1970. To that effect, there is no evidence, man. Because the villages are different, age discrepancies are there. And there is no proof of shifting. And another issue, my lord, that even though the father was there in fact, the existence itself is not there. So we may not go to that other aspect also, because from 1970 to 1993, there is no voter list. And continuous residence is necessary as per, my lord, 6, 8, 2, and 3, my lord, of the Citizenship Act. The continuous residence of the father is also not proof. Shifting is not proof. The father's existence prior to 1971 is not proof. The linked documents which the petitioner trying to bring by these Gambura certificates, these are not proof. So overall, my lord, from the readings of the entire opinion, the tribunal has given, my lord, proper opinion, and it may not be interfered. For oral evidence, your lordship, I have relied on I'm pointing out the judgments for reference, my lord. This judgment, my lord, 4020 of 2017 WPC. Asia Khatun is there. And another is, my lord, 1900 2019 WPC. 1900 2019. Another is, my lord, 562 of 2016. WPC 562 of 2016, my lord. There also it is clearly stated oral evidence is not enough in proceeding under Foreigners Act 1946. So apart from the oral evidence of the GW2, the documents doesn't support anything that the petitioner's father was there in prior to 1971. And in absence of that, my lord, the petitioner cannot be said that she's a citizen. That must be.
UMH,
RR cycle. RR cycle.
third MS, RR cycle. Lord Counsel for the petition. And Mr. A.I. Ali, Standing Council Election Commissioner of India. Also heard Mr. Zay Payeng, Standing Council from the Department of Assam. Order responding number 3 and 6. As well as Mr. P. Sharma. P. Sharma, Additional Senior Governor. Assam. First. Deputy Commissioner for responding number. Where is the records in original? Of JFT Vindicated R, case number 1773 of 2017. Of the Furnace Tribunal number 1, Kamrup Vindicated R. It was called for. Order is there. Come back in 5 minutes.
They have appeared SLC examination and admit card has been exhibited. But the school certificate, my lord, recently furnished to me, my lord. My lord, may I pay for, my lord, permitting to file an additional affidavit, my lord, into these 2 cases, my lord, enclosing the school certificate. Admit card is exhibited, my lord, but the school certificate is also necessary. My lord, we will file it, my lord, this week, and the matter may come up in the next week, my lord.
তো আপনার মোড়ে পার্টটা হয়ে এটা উপকার করতে আগস্ট
করা নাই, করা নাই। দিন কোর্টে কনসিডার করলে করবে না করলে না আদারওয়াইজ আমার কোনো ভালোই পাবে ডিম অফিসার স্যার
That's come back even in the air. We are releasing it from part heard. Okay? So file your affidavit.
my lord maybe taken up in the next week my lord.
We are not giving any date. We'll just say placed after 2 weeks. We'll release it from part heard because the last time we heard it was on 9th of August 2022.
My lord.
So I have not remembered anything.
That necessarily my lord, it should be hard
We do
fresh
not
my
know.
lord.
So we do not
Well-
know whether these bans will continue or
Well-
what will happen.
My lord, matter may come up in the next week my lord. I will file it tomorrow by
We
tomorrow
do
my lord.
not know whether these bans will continue
My lord,
further.
my
That's the
lord.
reason.
My lord.
So we release from the part heard. Whoever it is there, if we are
My-
sitting there, we'll again make your argument,
My
no
lord,
problem.
my lord.
Yes, Mr. Sharma? You want to file affidavit?
If it enclosing school certificate and Jamamandi my lord.
In respect of item number 5.
In respect in both the case my lord. I have a school certificate. But Jamamandi is only in item 6 my lord. Jamamandi and admit card. And school certificate, only school certificate in item 5.
Petitioner of WPC number 6735/2016. Wants to file an additional affidavit enclosing
School certificate.
his school certificate.
School certificate.
And the petitioner of WPC number 6735/2016 wants to file, also wants to file an additional affidavit enclosing admit card,
No my lord. School certificate and
school
Jamamandi.
certificate and copy of Jamamandi. Both the petitioners are husband and wife. And they are declared foreigner under the foreigners, under the Foreigners Act 1946. Prayer allowed, but the petitioner
Eh.
may file their
Oh,
additional affidavit as paid for
eh,
on or before within 2 weeks from, within 10 days from today.
Well.
By serving copies of such affidavit to the council for the respondents, councils for the respondents. Obtaining necessary. List after 2 weeks. Release from Potter, release from Potter, list after 2 weeks.
Deep love legislators.
Yes, Ms. Walida.
May I plead your lordship, petitioner's father's name recorded in the voter list 1966, that is annexure 2, page 16, my lord. Petitioner's father's name Moinuddin and mother's name is Albula Khatun, my lord. And also recorded 1970 voter list also, my lord, saying, my lord.
Yes, next.
Next, my lord, I have no other documents. I have annexed, my lord. Whatever documents is available, that is petitioners exhibited, my lord, in this, before this tribunal, my lord. And opinion is page 20, my lord. Others documents is available in this LCR, my lord.
Do you have the written statement with you? Have you adduced any evidence of any other witness?
My lord,
Okay, do one thing.
my lord, page 24, my lord, last para, my lord. DW1 as to why the name of parents of P or his parents' name,
No, we'll
Oh,
go
not
to that
my
part
lord.
later.
yes, my lord,
That's the order, right?
yes, my lord.
The impugn opinion. You have not annexed. Do you have a copy of your written statement?
No, my lord, I have not.
You read it. You read it loud so that they can also hear it.
My lord. Para 1, my lord, that the OP is bona fide citizen of India by birth and permanent resident of this above noted address. Para 2, that the above cited case is registered or mentioned without any reasonable ground or only on some false and concurrent and fabricated grounds. That para 3, that the opposite party was born and brought up Bheluguri Pathar under Dobaka police station in the district of Nagaon, Assam, and hence he is not a foreigner but an Indian citizen. Therefore, that the name of the father of opposite party has been enlisted in the voter list of 1966 under 92 Jamunamok LSA by part number 106, house number so and so. And as Moinuddin, son of Mojid, at village Veluguri Pathar, Moja, Jamunamok, PS Dabaka, district Nagaon. Para 5, that the name of the father of this opposite party has been also enlisted in the NRC voter list dated 1966 under 92 number Jamunamok LSC by code number so and so. Para 6, that the father's name of the opposite party has been enlisted in the voter list 1970 under house number 6, serial number 19, and village so and so. Para 7, that the name of this opposite party, his parents and his family members have been inserted in this voter list of 1997 under 90 number of Jamunamok LSC, part number 18, house number 47, serial number 154 to 156, and same village. Para 8, right, that the name of the opposite party and his family members have been enlisted in the voter list of 2005 LSC 90. Village Veluguri, Pathar, PS Dobaka, District Nagaon, Assam. Para 9, that the name of this opposite party and his family members enlisted in the voter list of 2011 LSC 90, but part number 31. Address also same. Para 10, that the name of this opposite party has been enlisted in this along with his wife under 90 LSC, but serial number, house number 269, serial number 148 and 149, same village. Para 11, that the electoral photo identity card has been issued by the electoral registration officer Huzai Nagaon, Assam. The name of this opposite party by serial number so and so. Para 12, that the certificate has been issued in this name of this opposite party by the local Sarkari Gaubhura, village Beluguri, Gao Pathar, police station, Pathar, police station that the opposite party is a permanent resident of his locality and he knows the opposite party is very well. Para 13. That in some documents linked in the documents of can recorders of the instant case, the name of this opposite party has been recorded as MD Okhilali inserted of his good name Okhilali, and his father's name has been recorded as an Moin Uddin inserted of his good name is Moin Uddin, MD Okhilali and Okhilali are the names of one and same persons, that is opposite party himself and Moinuddin and Moinuddin are the name of one and same persons. Para 14 that the allegations made in this in the instant case are all false and fabricated, and hence the above case is to be dismissed. Para 15. The above cited case is instituted only intending to harassing this opposite party. Para 16. That the police has never gone to the locality of this opposite party to properly and investigated the case, and to police has submitted the false fabricated reports in the case and against the opposite party. Para 17. That the case is not maintainable in law and is to be dismissed only for the end of justice.
Now, did
The-
the evidence,
My right.
evidence and affidavit is there?
My lord.
Kindly read.
And affidavit is DW1. DW1. I Okhilali alias Okhilali late Moinuddin and son of Moinuddin and Moinuddin, aged about 40 years, resident of Bheluguri Pathar, PS Madartali, PS Doboka, District Nagaon, Assam, do hereby and or solemnly affirm the declare as follows. Para 1. That I am bona fide citizen of India by birth and permanent resident above noted address. That is true. Para 2. That I was born and brought up the village Beluguri Pathar under PS Doboka district Nagaon, Assam. Para 3. That my father's name has been enlisted in the voter list 1966 under 92 LAC by serial number 21, house number 6, part number 106, village so and so. And para 4. That my father's name has been enlisted in the voter list 1970 under 92 LSA, serial number 19, house number 6, part number 106, village Beluguri Pathar, under Doboka PS, Nagaon, Assam. Moinuddin, son of Mojid Ali. Exhibit 2 is the certified copy of this voter list. Para 5. That my name and my family members' name has been enlisted in the voter list of 1997 under 90 LSC by serial number 152, 53, 54, 55, 56, house number 47, part number 18, village Beluguri Pathar, under Doboka PS, Doboka PS and district Nagaon, Assam. Exhibit 3, certified copy of this voter list. Para 6. That my name and my family members' name has been enlisted in the voter list of 2005 under 90 LSC by serial number so and so, and village also same, and exhibit 4, certified copy of the voter list. That is my lord 2005. Para 6. That my name and my family members' name has been enlisted in the voter list of 2011 under 90 LSA, and by serial number also same, and exhibit 5. Para 7. That my name and my family members' name has been enlisted in the voter list of 2014 under 90 LSC but serial number so and so, exhibit 6. That is the certified copy of this voter list 2014. Para 8, that the Gaubura of this village, Veluguri Patar, has been issued as certificate, the name of this stating that I am a permanent resident of the above noted address, exhibit 7, the said Gaubura certificate. Para 9, the school certificate has been issued in my name, issued by this headmaster of this Jamunamukh ME Madrasa, stating that I was a student of Jamunamukh ME Madrasa till 31/12/1985, but serial number so and so. A school certificate is exhibit 8. Para 10, that electoral photo identity card is exhibit 9. Para 11, that my actual and correct name is Akhil Ali, but my name in my case recorded instant case, my name has been recorded Akhil Ali, MD Akhil Ali, and in my school certificate, my name has been recorded Akhil Ali Borbhuya. Instead of my actual and correct name is Akhil Ali alias Akhil Ali Borbhuya. All are named and the same identical person. That is my name, and also my father's actual and correct name is Moinuddin. In my case record of this instant case, my father's name has been recorded Moinuddin. Then school certificate, my father's name has been recorded Moinuddin Borbhuya. Instead case and actual correct name is, my father's name is Moinuddin Borbhuya, alias Moinuddin. All are name of the same and identical person. That is my father's name. I have executed affidavit declaring my father's name, correct name, exhibit 10. That is affidavit. Para 12, that the police has never investigated the case properly. This is true. Para 13, that the allegation made in a process case are totally false and fabricated and concurrent and baseless. That is true. Para 14, that I am not a foreigner but Indian national by birth, and I was born and brought up same village. That is true. Para 15, that I am swearing this affidavit before this honorable tribunal. Doboka swears.
Now, you relied on the voter list of 1966, 1970, and then you have adduced the evidence of voter list of 1997.
My lord.
You have adduced evidence 1966 voter list, certified copy, where name of your projected father Moinuddin has been reflected
My lord.
from village Veloguri. Pathar. 1970 voter list, you have reduced evidence where the name of your father Moinuddin from Veloguri Pathar has been there in the voter list. Thereafter, in the voter list of 1997, name of your father along with you
My lord.
was reflected from same village Veloguri Pathar. So you tried to prove your case that you are the son of Moinuddin who existed during 1966 as well as in 1970, as his name was there in the voter list. And you have also adduced, you have exhibited a school certificate, Gaubura certificate, and but you have not adduced any evidence of the school headmaster who have issued that school certificate, as well as the village headman,
My lord.
right?
Yes.
There was no other evidence excepting this, you. So those two certificates that you have adduced of the village headman and the school certificate, where his name is shown as Akhiluddin Borbhuya, will not be accepted as an evidence because not been proved. Now, relying on this voter list of 1966, 1970, and 1997 of Veloguri Pathar, with your father Moinuddin, right? You have tried to establish the linkage between you and your father to be an Indian citizen. Now, read the cross. Read the cross.
Married, madam. More নাম অখিল আলী
It
হয়।
will be difficult for you to read in the vernacular.
No, my lord.
Okay, then carry on.
মোৰ নাম অখিল আলী হয়, আহিল আলী নহয়। মোৰ দেউতাৰ নাম স্বৰ্গীয় মইনুদ্দিন হয়। মোৰ ঠিকনা মোৰ সাক্ষাৎ দিয়া মতে হয়। মোৰ বৰ্তমান বয়স 41 বছৰ হয়। মোৰ ককা দেউতাৰ নাম স্বৰ্গীয় মজিদ। মোৰ দেউতা এবছৰমান থাকোঁতে মোৰ ককা দেউতাৰ মৃত্যু হয়। মোৰ ককা আইতাৰ নাম মনত নাই, তেওঁ কেতিয়া ঢুকাল মই নাজানো। মোৰ দেউতা আজিৰ পৰা 16 বছৰ আগতে ঢুকাল। মোৰ বয়স প্ৰায় 30 বছৰ থাকোঁতে মোৰ দেউতাৰ মৃত্যু হয়। মোৰ মাৰ নাম ছফিয়া খাতুন। মোৰ মাৰ বৰ্তমান বয়স হয় 60 বছৰ আৰু মোৰ বৰমাৰ নাম চাইৰিন নেছা মৃত্যু মোৰ বয়স 20 বছৰমান থাকোঁতে ঢুকাল। মোৰ দেউতাৰ তিনি ককাই ভাই আছিল। 1 নম্বৰ স্বৰ্গীয় গোলাম হুছেইন, দ্বিতীয় মইনুদ্দিন আৰু 3 নম্বৰ নুৰুদ্দিন। মোৰ দেউতা আৰু তেওঁৰ ককাই ভাই জীয়াই থাকোঁতে বেলুঘুৰি পথাৰ গাঁৱতে বসবাস কৰিছিল। মোৰ ককাই ভাই 5 জন। 1 নম্বৰ ইদ্ৰিছ আলী 50 বছৰ, দ্বিতীয় ইউছুফ আলী 48 বছৰ, তৃতীয় ইউনুছ আলী 46 বছৰ, ফ'ৰ্থ তছলিমা খাতুন 44 বছৰ, পঞ্চম হোৱাইৰ মাজতে কাণ্ট্ৰিত মাইলতে মই অৰ্থাৎ আখিল আলী 41 বছৰ আৰু মোৰ তলৰ সৰু ভাই ইয়াছিন আলী 39 বছৰ। ভেলুগুৰি পাথাৰ গাঁৱতে মোৰ ককাই দেউতাৰ দিনৰ পৰাই আছিলোঁ। এক্সিবিট 1 1966 ভোটাৰ লিষ্ট চিৰিয়েল নম্বৰ 21 নত মোৰ দেউতাৰ নাম আৰু মোৰ মা বাবাৰ নামো উল্লেখ নাই।
You read it again, this
Exhibit
particular
1
sentence.
1966 ভোটাৰ লিষ্ট চিৰিয়েল নম্বৰ 21ত মোৰ দেউতাৰ নাম, ইয়াত মোৰ নিজৰ মাৰ নাম, বৰমাৰ নাম উল্লেখ নাই।
Hmm.
Exhibit 2 1970 ভোটাৰ লিষ্টত ইয়াত চিৰিয়েল নম্বৰ 19ত মোৰ দেউতাৰ নাম আছে, ইয়াত মোৰ মাৰ অথবা মোৰ বৰমাৰ নাম উল্লেখ নাই। Exhibit 3 1997 ভোটাৰ লিষ্ট ইয়াৰে চিৰিয়েল নম্বৰ 152ত মোৰ দেউতাৰ নাম, চিৰিয়েল নম্বৰ 153ত মোৰ মাৰ নাম, চিৰিয়েল নম্বৰ 154ত মোৰ মাৰ নাম উল্লেখ আছে। 1970 চনৰ পৰাই 1997 ইংৰাজী চনৰ আগৰ সময়খিনিৰ ভোটাৰ লিষ্টত মোৰ বা আমাৰ পৰিয়ালৰ কাৰোবাৰ নাম নাই। নথকাভাৱে কোনো আখ্যা মোৰ সাক্ষাৎ নাই। Exhibit 4 ভোটাৰ লিষ্ট of 2005ত ইয়াত মোৰ গাঁৱৰ নাম ভেলুগুৰি হিচাপে আছে। বেলুগুৰি পথাৰ নাই, য'ত মই বৰ্তমান থাকোঁ। ইয়াত চিৰিয়েল নম্বৰ 893ত মোৰ আৰু 894ত মোৰ পত্নীৰ নাম উল্লেখ আছে। Exhibit 5 ভোটাৰ লিষ্ট of 2011 ইয়াত চিৰিয়েল নম্বৰ 145ত মোৰ নাম আৰু চিৰিয়েল নম্বৰ 146ত মোৰ পত্নীৰ নাম আছে। Exhibit 6 ভোটাৰ লিষ্ট of 2014 ইয়াত চিৰিয়েল নম্বৰ 148ত মোৰ নাম আৰু 149ত মোৰ পত্নীৰ নাম আছে। Exhibit 7 চৰকাৰী গাঁওবুঢ়াৰ প্ৰমাণ পত্ৰ, য'ত মই বেলুগুৰি পথাৰত থকা বুলি উল্লেখ আছে। Exhibit 8 মোৰ স্কুল চাৰ্টিফিকেটত, য'ত মই ক্লাছ 6লৈ পঢ়া বুলি দেখুৱাইছো। ইয়াতে স্কুল চাৰ্টিফিকেট মতে মোৰ ডেট অফ বাৰ্থ 31/12/1974। Exhibit 9 ফটো আইডেন্টিটি অফ, য'ত মোৰ ফটো আইডেন্টিটি অফ ভোটাৰ লিষ্টত, য'ত মোৰ নাম অখিল আলী আৰু মোৰ দেউতাৰ নাম লেট মইনুদ্দিন হিচাপে দেখুওৱা আছে। Exhibit 9 মতে 1/10/2013ত মোৰ বয়স আছিল 39 years হিচাপে উল্লেখ কৰা আছে। Exhibit 10 মোৰ অন্যান্য অন্যান্য নামবিলাক একে নামৰ হোৱাৰ শপতনামা আৰু তেওঁ ক'বলগীয়া নাই আৰু মোৰ ক'বলগীয়া নাই।
Okay.
That's my
Now
my-
just
my lord.
take your read petition. Read petition. Don't close it. Don't close it, that record. Keep it there and take out your read petition. Page 17. That's the certified copy of the voter list of 1966. Right?
My lord.
Whose name is there?
My lord, serial, that is Moinuddin is. petitioner's
Moinuddin, son of Mojid.
father. My, that is petitioner's father's, my lord.
Right.
And thereafter, my lord, and
Ghulam Hussain,
my lord,
son of Mazid.
my lord,
Is it 40 years
my lord,
or 40 something? It's not legible
lord.
here.
my lord,
And the Moinuddin starts with some age, it is 50 or something. It starts with 5. Then the name of Anbul Khatun,
my lord, that is petitioner's mother's, my lord.
wife of Moinuddin. Is it starts with 3. Then Nur Uddin,
That is.
son of
petitioner's uncle,
Mazid.
my lord,
Again, it starts with 3. Is number 19.
my lord,
Moinuddin,
my lord,
your projected father, son of Mazid, 55 years. Ghulam Hussain, son of Mazid, your uncle, is it about 49 years. Anbul Khatun, wife of Moinuddin, is it 36 years. And Nuruddin, son of Mazid, your projected grandfather, is it 34.
my lord.
Now come to the cross of the proceeding. There he said,
My lord,
মোৰ দেউতাৰ এবছৰমান থাকোঁতেই মোৰ ককাৰ মৃত্যু হৈছে. Is it there?
my
You have
lord,
read?
my lord.
Now, how come the existence of Ghulam Hussain and Nuruddin came if the grandfather of the projected father expired while he was 1 year? Number 1. Number 2, the seriality of your father and your brothers. You said Ghulam Hussain, late Ghulam Hussain. You see in the cross-examination, you have very clearly said Ghulam Hussain is senior.
My lord,
Then comes your father.
my lord,
Then comes your uncle.
my lord,
You have said that in the voter list of 1966 and in 1970, neither the name of your Burma nor your mother was in the voter list,
my lord,
right? And you have said your name of your mother was there in the voter list of 1997. From the record, you see what is the name of your mother. From the record, you see the voter list of 1997. Where your name figured along with your parents.
my lord.
Is the name of Anbul Khatun there?
No, my lord. My lord, actually, as a Sophia Khatun, my lord, that is wrongly recorded.
We do not know.
Yes, my lord.
Now you have said that since 1970 to 1997,
My lord,
there was no voter list in the name of your father, in name of you or anyone in your family for which you could not place it as evidence. 1970 চনৰ পৰা 1997 চনলৈ মোৰ বা পৰিয়ালৰ কাৰো নাম ভোটাৰ লিষ্টত নাই সেইকাৰণে সাক্ষৰ দিব নোৱাৰিলো. You have said so.
my lord.
So
I have, my lord, also another voter list, my lord, that is 79 and 85. Also, my lord, petitioner's father's name and petitioner's mother's name also recorded, and others, uncle name is also recorded, my lord.
that was not
But I
before the
collect
tribunal.
from this, my lord.
That was not before the tribunal.
No, my lord.
Then what we can do? If it was there, it should have got a review petition. Immediately,
My lord, at this point, time of, I have not collect, my lord, now I am.
whether it's a
my lord,
certified copy,
No, my lord, that is
it is
computerized. my
not a
lord.
certified copy.
If your lordship permits, my lord, I have applied for the certificate copy, my lord.
That's, at this stage, what can we do?
My lord, I have
Just
so
tell
many
us.
voter lists is there, my lord, that is the 1960, and my lord, 1966, 1966, my lord, that is certified copy. Thereafter, my lord, 1970, and my lord, 71.
When you have said in your evidence that since 1970 to 1997, there is no voter list
My lord,
in the name of you or in the name of anyone of your family, right?
my lord,
For
that
which
is-
you could not adduce
Yes.
evidence.
my lord,
Now,
that
as
is-
per section 6A,
Mhm.
2 and 3 of the Citizenship Act,
my lord,
there is a requirement of continuous residence.
my lord,
To establish that for a continuous residence, you have to prove it from something.
my lord. I have documents, my lord. 1989 voter list also, my lord, I have, my lord, that is, yes,
That's
but,
the reason we are asking
my
you
lord,
whether these are certified copies of voter list.
my lord, that is, my
Did you
lord,
adduce these evidence before the tribunal?
no, my lord. But my lord,
If
that-
you read the recent judgment of the apex court regarding the circular, we've been repeating and repeating. Even there is something, some mistake, accepting the specified provisions in that judgment, which was a reiteration of the previous judgment of the certiorari. Even if you read the Muslim Mandal, you will see. Accepting that, the court will not interfere with such orders of the tribunal. And that is why, in fact, the recent judgment of Justice Paldiwal, there was no requirement. If you read that particular judgment, if you see, that is why they have given a full-length discussion on the writ of certiorari. Because the court found that in that order, in that particular case, there was a wrong exercise of certiorari. That is why they have, in that particular judgment, the Honorable Apex Court have discussed at length, giving all pros and cons regarding certiorari. If you read it properly, then you will see the right of certiorari can be exercised only up to what extent. Same thing you will see in the Muslim Mandal's case and also the previous judgments of our High Court as well as of the Apex Court. Now, from the evidence that the petitioner adduced before the tribunal, whether he succeeded to prove his linkage of one Moinuddin, that his projected father, who was at Bheloguri Pothar in the year 1966 and 1970, is the same person who existed in the year 1997 in the same village. Whether the proceedee or the petitioner could prove it before the tribunal or not, tell us. Because you have read the evidence, the school certificate not proved, the certificate issued by the village headman not proved. In that circumstances and the evidence adduced by the proceedee himself, whether he could prove that Moinuddin, son of Mazid, as your projected father and projected grandfather, was the same person of 1966, 1970, and that of 1997 of village Bheloguri Pothar or not. Yes. In 1997, there was one Moinuddin, son of Mazid. There's no doubt about
my lord.
it, right?
In
And the
97
name of petitioner figured along with Said Manuddin in the voter list of 99%. But how do you show that Said Manuddin existed continuously as required under section 6A, 2 and 3 of the Citizenship Act? And he proved that a procedure is required to prove under section 9 of the Foreigners Act.
If your lordship permits, I have filed any additional affidavit, my lord. All other voter lists continuously have, my lord.
Even if we allow you to file an additional affidavit, will you be able to consider it in this report now at this stage while exercising the power under such a?
My lord. Up to
See,
date
the
voter list I
legislation,
have, my
the
lord.
legislators while framing these laws, they have given all the specific provisions,
My lord.
whether they have given the power of review, they have given the power, everything. Right?
My lord.
Now, well, that is the reason we are asking you whether in exercising the power under statutory, can we do it now? Even if you put anything before the tribunal. So we have to consider any such order passed by the tribunal only within that very period, not beyond that. Have you ever stated in your petition that you have the voter list of your projected father and projected mother continuously after 1970 till 1997?
My lord,
You
that,
say,
no, my lord, actually, my lord, that point of time petitioner have not hand over, my lord, to this, all other documents.
that
my
is the
lord.
reason.
Okay.
We have to only see the order passed by the tribunal, whether it is bad in law
My lord, petitioner
or
have,
even conformity with law.
in petition I have neither, my lord,
If you had any such documents in your hand, appropriate provisions were there. It's not that you didn't had any remedy.
my lord, only from my lord, all other documents have, my lord, voter list.
True, you might have. But can you look into it now? That's the thing we're asking you. If you can show us that we can accept these documents now,
My lord, except these documents, my lord, only government certificate and school certificate, that much, my lord. And all other voter lists, my lord, have. That is the, my lord, sufficient, my lord. Continuously, my lord. My lord.
okay. Yes, Mr. Fine.
Hello, not fine. The document is not here, so may I go to the record? Document is administered on it. Hello, fine.
That's why record is before you now.
Yes.
You can tell us from the records. Mr. Pang, before you proceed further, you have that judgment of the Honorable Apex Court.
Yes.
Read, I'll show you the which particular paragraphs you'll read. Starts with. Give me that. 54, I believe.
Yes,
Sharma. Look. To what they have. না মিলত নালাগে হেৰি কৰি থোৱা আছে See online. Online. That's it. Go to capital. Look at. Go to small f, L to S. Capital 996. Yes, to আপনি অনলাইনত এই হেৰি দিছিলে ন মেইলত আছিল মেইলৰ পৰা আহিছে, আহিছে। Before that, মানে read from 50. Ms. Swajita, please take your seat. Read slowly so that others can also understand.
Before we close the matter, we would like to observe something important to the aforesaid context. Two cardinal principles of law governing exercise of extraordinary jurisdiction under Article 226 of the Constitution, more particularly when it comes to issue of writ of certiorari. The first cardinal principle of law that governs the exercise of extraordinary jurisdiction under Article 226 of the Constitution, more particularly when it comes to the issue of a writ of certiorari, is that in granting such a writ, the High Court does not exercise the power of appellate tribunal. It does not review or reweigh the evidence upon which the determination of the inferior tribunal purports to be based. It demolishes the order which it considers to be without jurisdiction or palpably erroneous, but does not substitute its own views for those of the inferior tribunal. The writ of certiorari can be issued if an error of law is apparent on the face of the record. A writ of certiorari, being a high prerogative writ, should not be issued in mere asking. Then paragraph 52, my lord. The second cardinal principle of exercise of extraordinary jurisdiction under Article 226 of the Constitution is that in a given case, even if some action or order challenged in the writ petition is found to be illegal and invalid, the High Court, while exercising its extraordinary jurisdiction, thereunder can refuse to upset it with a view to doing substantial justice between the parties. Article 226 of the Constitution grants an extraordinary remedy, which is essentially discretionary, although founded on legal injury. It is perfectly open for the writ court exercising this inflexible power to pass such orders as public interest, divorced from the realities of the fact situation of the case. While administrating law, it is to be tempered with equity, and if the equitable situation demands after setting right the legal formulations, not to take it to the logical end, the High Court would be failing its duty if it does not notice equitable consideration and mold a final order in exercise of its extraordinary jurisdiction. Any other approach would render the High Court a normal court of appeal, which it is not. The essential features of writ of certiorari, including brief history, have been very exhaustively explained in by B.K. Mukherjee Justice in T.C. Basappa versus Nagappa, AR 1954 SC 440. The court held that a writ in the nature of certiorari could be issued in all appropriate cases and in appropriate manner, so long as the broad and fundamental principles were kept in mind. Those principles were delineated as follows. This is my quotation from para 7. In granting a writ of certiorari, the Superior Court does not exercise the power of an appellate tribunal. It does not review or reweigh the evidence upon which the determination of the inferior tribunal purports to be based. That it demolishes the order which it considers to be without jurisdiction or palpably erroneous, but does not substitute its own view for those of the inferior tribunal. Then the supervision of the Superior Court exercised through writs of certiorari goes on 2 points, as has been expressed by Lord Sommer in King versus Nutbell Liquors Limited, 1922, 2 AC 128, 156. One is the area of inferior jurisdiction and the qualifications and the conditions of its exercise. The other is the observance of law in the course of exercise. Then, certiorari may lie and generally granted when a court has acted without or in exercise of its jurisdiction. Then, para 54 minutes. Relying on T.C. Basappa Supra, the constitution bench of this court in the case of Hari Vishnu Kamat Supra laid down the following proposition as well as established. Number 1, certiorari will be issued for correcting erroneous errors of jurisdiction as and when inferior court or tribunal acts without jurisdiction or in exercise of it or fails to exercise it. Number 2, certiorari will be issued when the court or the tribunal acts illegally in exercise of its undoubted jurisdiction, as and when it decides without giving an opportunity to the parties to be heard or violates the principle of natural justice. Then number 3, the court issuing a writ of certiorari acts as exercise of supervisory and not appellate jurisdiction. One consequence of this is that the court will not review finding of fact reached by the inferior court or tribunal, even if they are erroneous. Then para 55 says, this court explained that a court which has jurisdiction over a subject matter has jurisdiction to decide wrong as well as right. And when the legislature does not choose to confer a right of appeal against that decision, it would be defeating its purpose and policy if a superior court were to rehear the case on the evidence and substitute its own findings in certiorari. Para 56. In Site Jacob versus case Radhakrishnan, year 1964, SC 477, Justice P.B. Gajendra Garkar, Chief Justice, speaking for the constitution bench, placed the matter beyond a position of doubt by holding that a writ of certiorari can be issued for correcting errors of jurisdiction committed by inferior courts or tribunal. The observation of this court in para 7 are worth taking note of. The question about the limits of jurisdiction of the High Court in issuing a writ of certiorari under Article 226 has been frequently considered by this court, and the true legal position in that behalf is no longer in doubt. A writ of certiorari can be issued for correcting errors of jurisdiction committed by inferior courts or tribunal. These are cases where orders are passed by the inferior courts or the tribunal without jurisdiction, or is in excess of it, or as a result of failure to exercise jurisdiction. A writ can similarly be issued where the exercise of jurisdiction conferred on it, the court or the tribunal acts illegally or improperly, as for instance, it decides a question without giving an opportunity to be heard to the party affected by the order, or where the procedure adopted in dealing with the dispute is opposed by the principles of natural justice. There is, however, no doubt that the jurisdiction to issue a writ of certiorari is a supervisory jurisdiction, and the court exercising it is not entitled to act as an appellate court. The limitation necessarily means that the findings of the facts reached by the inferior court or tribunal as a result of the appreciation of evidence cannot be reopened or questioned in writ proceeding. An error of law which is apparent on the face of the record can be corrected by a writ, but not an error of fact, however grave it may be, appeared to be. In regard to a finding of facts recorded by the tribunal, a writ of certiorari can be issued if it is shown that in recording the said finding, the tribunal had erroneously refused to admit admissible and material evidence, or had erroneously admitted inadmissible evidence, which has influenced the impugned finding. Similarly, if a finding of the fact is based on no evidence, that would be regarded as an error of law, which can be corrected by a writ of certiorari. In dealing with this category of case, however, we must always bear in mind that the finding of the fact recorded by the tribunal cannot be silenced in a proceeding for a writ of certiorari on the ground that the relevant and material evidence adduced before the tribunal was insufficient or inadequate to sustain the impugned finding. The adequacy or sufficiency of evidence laid on a point and the inference of the fact to be drawn from the said finding are within the exclusive jurisdiction of the tribunal, and the said points cannot be agitated before writ court. It is within the limits that the jurisdiction conferred on the High Court under Article 226 to issue a writ of certiorari can be legitimately exercised. Then paragraph 57, madam. Here it is. In Surya Dev Rai versus Ramchandra Rai, 2003, 6 SCC 675, a bench of 2 judges held that the certiorari's jurisdiction, though available, should not be exercised as a matter of course. The High Court would be justified in refusing the writ of certiorari if no failure of justice had been occasioned. In exercising the certiorari jurisdiction, the procedure ordinarily followed by the High Court is to command the inferior court or tribunal to certify its record or proceeding to the High Court for its inspection, so as to enable the High Court to determine whether on the face of the record the inferior court has committed any of the errors or as explained by the court in Hari Vishnu Kumar versus Ahmed Ishaq, year 1955, Supreme Court 233, occasioning failure of justice. From the aforesaid, it could be said in terms of the jurisdictional error that want of jurisdiction may arise from the nature of subject matter, so that the inferior court or the tribunal might not have the authority to enter on the inquiry. It may also arise from the absence of some essential preliminary or jurisdictional fact, where the jurisdiction of a body depends upon a preliminary findings of the fact in a proceeding for a writ of certiorari. The court may determine whether or not that the finding of the fact is correct. The reason is that by wrongly deciding such a fact, the court or the tribunal cannot give itself jurisdiction. In Anisminic Limited versus Foreign Compensation Commission, 1969, 147, the House of Lords has given a very broad contention to the concept of jurisdictional error. It has been laid down that a tribunal exceeds jurisdiction not only at the threshold when it enters into inquiry, which it is not entitled to undertake, but it may enter into an inquiry within its jurisdiction in the first instance and then do something which should deprive it of its jurisdiction and render its decision a nullity. In the words of Lord Reid. But there are many cases where although the tribunal had jurisdiction to enter on the inquiry, it has done or failed to do something in the course of the inquiry, which is of such a nature that its decision is a nullity. It may have given its decision in a bad faith. It may have made a decision which it had no power to make. It may have failed in the course of the inquiry to comply with the requirements of the natural justice. It may, in perfect good faith, have misunderstood the provisions giving in power to act, so that it failed to deal with the question remitted to it and decided question which not remitted to it. It may have refused to take into account something which it was required to take into account, or it may have based its decision on some matter which, under the provision setting it up, it had no right to take into account. I do not intend this list to be exclusive. Then for us 60 minutes. So far as the errors of law are concerned, a writ of certiorari could be issued if an error of law is apparent on the face of the record. To attract the writ of certiorari, a mere error of law is not sufficient. It must be one which is manifest or patent on the face of the record. Mere formal or technical errors, even of law, are not sufficient so as to contract a writ of certiorari. As reminded by this court time and again, this concept is identified and indefinite. This concept is indefinite and cannot be defined precisely or exhaustively, and so it has to be determined judiciously on the face of the facts of each case. The concept, according to this court, in KM Chanamugam versus the SRVS Private Limited, near 1963 SC 1626, is comprised of many imponderables. It is not capable of precise definition, as no objective criterion could be laid down. The apparent nature of the error, to a large extent, being dependent upon the subjective element, a general test to apply, however, is that no error could be said to be apparent on the face of the record if it is not self-evident or manifest. If it requires an examination or argument to establish it, if it has to be established by a long drawn out process of reasoning or lengthy or complicated argument on points where there may be considerably be two opinions, then such an error would cease to be an error of law. In para 6. However, in our opinion, such a test should not be applied in a straitjacket formula and may fail because what might be considered by one judge as an error self-evident might not be considered so by another judge. At this stage,
Mr. Payne,
Hmm.
the remaining paragraph, now they have come to the last issue.
Yes.
We'll come back at 2 and you just read up. We'll finish it. We'll start at para 62 of that judgment.
yes, at this stage, it may not be out of place to remind ourselves of the observation of this code in Syed Yaqub on this point, which are as follows. Code. Where it is manifest or clear that the conclusion of law recorded by an inferior court or tribunal is based on an obvious misinterpretation of the relevant statutory provision or something in the ignorance of it, or maybe even in disregard of it, or is expressly be corrected by a writ of certiorari, expressly founded on reason which are wrong in law, the said conclusion can be corrected by a writ of certiorari. Certiorari would also not lie to correct mere errors of fact, even though such error may be apparent on the facts of the record. The writ jurisdiction is supervisory, and the court exercising it is not to act as an appellate court. It is well settled that the writ court would not reappreciate the evidence and substitute its own conclusion of fact for the recorded by the adjudicating body, be it a court or a tribunal. A finding of fact, however erroneous, recorded by a court or tribunal cannot be challenged in proceedings for certiorari on the ground that the relevant and material evidences adduced before the court or the tribunal was insufficient or inadequate to sustain the impugned finding. It is also well settled that adequacy or sufficiency of evidence laid on the point and the inference of fact to be drawn from the said finding are within the exclusive jurisdiction of the tribunal, and these points cannot be agitated before the writ court. In para 63. In the aforesaid context, it will be profitable for us to refer to the decision of this court in the case of Indian Overseas Bank versus IOB Staff Canteen Workers Union 2004 SCC 245. This court observed as under. Quote, the findings of the fact recorded by a fact-finding authority duly constituted for the purpose and which ordinarily should be considered to have become final cannot be disturbed for the mere reason of having been based on materials or evidence not sufficient or credible in the opinion of the writ court, or warrant those findings at any rate, as long as they are based upon such material which are relevant for the purpose, or even on the ground that there is yet another view which can be reasonably and possibly undertaken. Quote end. However, 64. However, we may clarify that findings of fact based on no evidence or purely on surmises and conjectures, or which are perverse points could be challenged by way of certiorari. As such, findings could be regarded as an error of law. Thus, from the various decisions referred to above, we have no hesitation to reaching to the conclusion that a writ of certiorari is a high prerogative writ and should not be issued on mere asking. For the issue of writ of certiorari, the party concerned has to make out a definite case for the same, and is not a matter of course. To put it pitchly, certiorari shall issue to correct errors of jurisdiction, that is to say, absence, excess, or failure to exercise, and also when the exercise of undoubted jurisdiction, there has been illegality. It shall also issue to correct an error in the decision or determination itself, if it is an error manifest on the face of the proceedings. By its exercise, only a patent error can be corrected, but not also a wrong decision. It should be well remembered at the cost of repetition that certiorari is not appellate, but only supervisory. Para 66. A writ of certiorari, being a high prerogative writ, is issued by a superior court in respect of the exercise of jurisdictional, judicial or quasi-judicial function by another authority when the contention is that the exercising authority had no jurisdiction or exceeded the jurisdiction. It cannot be denied that the tribunals or the authorities concerned in these beds of appeals had the jurisdiction to deal with the matter. However, the argument would be that the tribunal had acted arbitrarily and illegally, and that they had failed to give proper finding on the facts and circumstances of the case. We may only say that, while adjudicating a writ application for a writ of certiorari, the court is not sitting as a court of appeal against the order of the tribunals to test the legality thereof, within a view to reach a different conclusion. If there is any evidence, the court will not examine whether the right conclusion is drawn from it or not. It is well established principle of law that a writ of certiorari will not lie where the order or decision of the tribunal or authority is wrong in matter of facts or on merit. In para 767, we may quote with profit a decision of this court in the case of Satya Narayan Lakshmi Narayan Hegde Supra, to understand the true purport and meaning of an error apparent on the face of the record, or an error which could be termed as self-evident. The facts of that case were as below. 60. The respondent made an application in the revenue court of the Mamlattar or CC praying for the delivery of possession of property, which the appellant was on the date possessing as the tenant under him on the basis of Malgeni did executed by the respondent's predecessor in interest, in favor of the appellant's predecessor in interest. The case was governed by the Bombay Tenancy and Agricultural Land Act 1948, and one of the questions in controversy was whether, before applying for the delivery of possession, it was incumbent upon the respondent to have given a notice terminating the tenancy. The Mamaltar made an order for possession in favor of the respondent. The collector allowed the appeal and set aside the order of Mamaltar. The Bombay Revenue Tribunal, to whom the matter was taken up on appeal, held that as the respondent had failed to terminate the tenancy by notice before instituting the action for ejectment, he was not entitled to entertain the application for recovery of possession. Thereafter, the respondent made an application to the High Court of Bombay under Article 227 of the Constitution of India for the questioning of the order of Revenue Tribunal and the collector, and for the restoration of the order of the Mamaltar. The High Court was of the opinion the tribunal had committed an error which was apparent on the face of the records in holding that an order of possession could not be made unless a notice terminating the tenancy had been given before the institution of the proceeding, and it used the writ of certiorari quashing the order of the tribunal and restoring that of the Mamaltadar. An appeal was filed against the order of the High Court, and this court reversed the order on the ground that alleged error in the judgment of the Bombay Revenue Tribunal, namely that an order for possession could not be made unless a previous notice required by the Section 14 of the Bombay Tenancy and Agricultural Lands Act 1948 had been given, was not an error apparent on the face of the record, so as to be capable of being corrected by a writ of certiorari, and the following observations were made by this court. Quote 17 and quote 7. An error which has to be established by a long drawn process of reasoning on points where there may conceivably be two opinions can hardly be said to be an error apparent on the face of the record. As the above discussion of the revealed contention show that, so the alleged error in the present case is far from self-evident, and if it can be established, it has to be established by lengthy and complicated argument. We do not think such an error can be cured by a writ of certiorari according to the rule governing the powers of the Superior Court to issue such a writ. Quote N. Para 17. We may also quote with profit one more decision of this court explaining the true scope of issue of writ of certiorari and what is an error apparent on the face of the record, which could be corrected by issue of High Court, issue of a high prerogative writ like certiorari. In case of Ibrahim Abu Bakr and Hawabai Abu Bakr versus Custodian General of Evacue Property, New Delhi, 1952, 1 SCC 798. The court made the observation in para 12, 13, 14, and 15, which was we quote below. Quote, para 12. The remaining three questions canvassed before us, unless they are of such a nature as would make the decision of the respondent dated 13/5/1950 a nullity, cannot be the subject matter of writ of certiorari. It is plain that such a writ cannot be granted to quash the decision of an inferior court within the jurisdiction of the ground that the decision is wrong. Indeed, it must be shown before such a writ is issued that the authority which passed the order acted without jurisdiction or in excess of it or in violation of the principle of natural justice. Want of jurisdiction may arise from the nature of the subject matter, so that the inferior court might not have authority to enter into the inquiry or upon some part of it. It may also arise from the absence of some essential preliminary or upon the existence of some particular facts collateral to the actual matter which the court has to try and which are conditions precedent to the assumption of jurisdiction by it. But once it is held that the court has jurisdiction, but while exercising it, it made a mistake, the wronged party can only take the course prescribed by the law for setting matters right, in as much as a court has jurisdiction to decide rightly and as well as wrongly. The three questions agitated before us do not seem to be questions which bear upon the jurisdiction of the Court of Appeal or its authority to entertain them. Para 13 says, it was contended that no court of limited jurisdiction can give itself jurisdiction by a wrong decision on a point collateral to the merits of the case upon which the limit of its jurisdiction depends, and that the questions involved in the appeal before the respondent were collateral to the merits of the case. As pointed out by Lord Fisher Emer in R versus CIT, the formula enunciated above is quite plain but its application is often misleading. The learned master of rules classified the cases under two categories. Thus, quote, when an inferior court or tribunal or body which has to exercise the power of deciding facts is first established by Act of Parliament, the legislature has to consider what power it will give that tribunal or body. It may in effect say that if a certain state of facts exists and is shown to such tribunal or body before it proceeds to do certain things, it shall have jurisdiction to do such things, but not otherwise. There it is not for them conclusively to decide whether the state of facts exists, and if they exercise the jurisdiction without its existence, what they do may be questioned, and it will be held that they have acted without jurisdiction. But there is another state of things which may exist. The legislature may entrust the tribunal or body with a jurisdiction which includes the jurisdiction to determine whether the preliminary state of facts exists as well as the jurisdiction. And on finding that it does exist, to proceed further or do something more. When the legislature are establishing such a tribunal or body with limited jurisdiction, they also have considered whatever jurisdiction they give them, whether there shall be any appeal from their decision or otherwise there will be none. In the second of the two cases I have mentioned, it is erroneous application of the formula to say that the tribunal cannot give themselves jurisdiction by wrongly deciding certain facts to exist, because the legislature gave them jurisdiction to determine all the facts, including the existence of the preliminary facts on which the further exercise of their jurisdiction depends. And if they were given jurisdiction so to decide without any appeal being given, there is no appeal from such exercise of their jurisdiction. In paragraph 14, the tribunal constituted to hear appeals under section 24 has been constituted in these terms. Any person aggrieved by an order made under section 7, section 16, section 19, or section 38 may prefer an appeal in such manner and within such time as may be prescribed. A, to the custodian where the original order has been passed by deputy assistant custodian. B, the custodian general where the original order has been passed by the custodian, an additional custodian, or an authorized deputy custodian. 15. Like all courts of appeal exercising general jurisdiction in civil cases, the respondent has been constituted an appellate court in the words of widest amplitude, and the legislature has not limited his jurisdiction by providing that such exercise will depend on the existence of any particular state of fact. Ordinarily, a court of appeal has not only jurisdiction to determine the subordinate soundness of the decision of the inferior court as a court of error, but by the very nature of things, it has also jurisdiction to determine any points raised before it in the nature of preliminary issue by the parties. Such jurisdiction is inherent in its very constitution as a court of appeal. Whether an appeal is competent, whether a party has locus standi to prefer it, whether the appeal in substance is from one or another order, and whether it has been preferred in proper form and within the times prescribed, are all matters for the decision of the appellate court so constituted. Such a tribunal falls within the clause 2 of the classification of the master of the rules. In these circumstances, it seems to us that the order of the High Court of Punjab that a writ of certiorari would not be issued to the respondent quashing the order dated 13/5/1950 was right. We are further of the opinion that none of the contentions raised has any merit whatsoever. Then para 72, my lord. The court in Perry and Company Limited versus Commercial Employee Association Madras 1952 1 SCC 442 held. Quote, the records of the case do not disclose any error apparent on the face of the proceeding or any irregularities in the proceeding adopted by the Labour Commission, which goes contrary to the principles of natural justice. Thus, there was absolutely no grounds here which would justify a superior court in issuing a writ of certiorari for removal of an order or proceeding of an inferior tribunal vested with power of exercise judicial or quasi-judicial functions. What the High Court has done really is to exercise the power of an appellate court and correct what it considered to be an error in the decision of the Labour Commission. This obviously it can do. This obviously it cannot do. The position might have been different if the Labour Commissioner had omitted to decide a matter which he was bound to decide, and in such cases, a mandamus might legitimately issue commanding the authority to determine question which it left undecided. But no certiorari is available to quash the decision passed with jurisdiction by an inferior tribunal or mere ground that such decision is erroneous. The judgment of the High Court, therefore, in our opinion, is plainly unsustainable. Para 73. In another case, the same court held a certiorari cannot be granted to quash the decision of the appellate tribunal on this point on the ground that decision is wrong. In Ibrahim Abu Bakr versus the Custodian General of Evacu Property, 1952. 74. It is therefore clear that in all findings on matters of facts and interpretation of law, except in cases of defective jurisdiction, the decision of the tribunal must be deemed to be final. Then para 75. The position is authoritatively summed up in Halsbury Law of England in volume 11 in para 1493, where it is laid down thus. Where the proceedings are regular upon their facts, and the magistrate had jurisdiction, the superior court will not grant writ of certiorari on the ground that the court below has misconceived a point of law. When the court below has jurisdiction to decide a matter, it cannot be deemed to exceed or abuse its jurisdiction merely because it incidentally misconstrue a statute or admits illegal evidence or rejects legal evidence or misdirect itself as to weight of the evidence or convicts without evidence. Nor will certiorari be granted to quash the decision of an inferior court within its jurisdiction on the ground that the decision is wrong in matter of fact, and the court will not hear evidence impeaching the decision of the facts. Quote end. Para 76. Similarly, in the case reported in Colonial Bank of Australia versus William, it is observed by their lordship thus. Quote, the question is whether the inferior court has jurisdiction to enter upon the inquiry and not whether there has been miscarriage of the procedure in the course of inquiry. At page 443 of the same case, the learned judges observed an adjudication by a judge having jurisdiction over the subject matter is if no defect appears on the face of it to be taken as conclusive of facts stated therein. The case in 5 PC 417 has been approvingly cited by Fazal Ali Justice, who held Rai Bris Ras Krishna versus SK Shaw and Brothers in 1951 SCC 102 that an error of law does not constitute an error of jurisdiction, and that a wrong decision on facts or law cannot be questioned in a civil court. Para 77. It being open to the tribunals to come to one or the other conclusion on the materials before them, it cannot be any means be said that the decisions are incorrect so as to attract the extraordinary jurisdiction for inference by a writ of certiorari. In King's Bench decision in R versus Brickton, an area rent tribunal, 1951, all year 946, Lord Goddard CJ observed that, quote, as the tribunal had observed, all the formalities of the act had offended against none of the provisions or against the regulations met under it. There was no ground for holding that the tribunal's determination was not in accordance with law, and therefore the motions for certiorari and amendments should be refused. Para 17. The purpose of certiorari, as we understood, is only to confine the inferior tribunal within their jurisdiction so as to avoid the irregular exercise or non-exercise of illegal assumption of it, and not to correct errors of findings of fact or interpretation of law committed by them in exercise of the power vested in them under the statute. The accepted rule is that where a court has jurisdiction, it has a right to decide every question which crops up in the case and whether its decision is correct or otherwise. It is bound to stand until reversed by a competent court. The court in G. Hirappa Pillai versus Raman and Raman Limited, Kumbakonam, Tanjiro District, 1952, 1 SCC 334 observed, quote, such writs as are referred to Article 226 are obviously intended to enable the High Court to issue them in grave cases where the subordinate tribunal or bodies or officers act wholly without jurisdiction or in excess of it or in violation of the principle of natural justice or refuse to exercise the jurisdiction vested in them, or there is an error apparent on the face of the record, and such act, omission, error, or excess had resulted in manifest injustice. However extensive the jurisdiction may be, it seems to us that it is not so wide or large as to enable the High Court to convert itself into a court of appeal and examine for itself the correctness of the decision impugned and decide what is the proper view to be taken or the order to be met. Good. Para 79.
Rest are not required because that is the
Yes,
decision of the.
that's decision of the. So this is the observation with regard to certiorari.
Now, from the records you tell us.
From the records, my lord, your lordship may kind of just I'll read out the evidence cross part of the my lord, the proceeding. And we may also refer the voter list of 1960 exhibit annexure page 14, page 17 and 19. And also in WS, In cross, she has said, मतलब more may read the cross, मतलब for
Please.
division. More नाम अखिल अली होय. अखिल अली होय. अखिल अली নহয়. More deuter नाम स्वर्गीय মইনুদ্দিন.
অখিল আলী হয়, অকিল আলী নহয়।
अखिल अली होय, मतलब AKI.
অকিল আলী হয়, অখিল
Not
আলী নহয়।
अखिल अली. More deuter नाम স্वर्গীয় মইনুদ্দিন হয়. মইনুদ্দিন হয়. মোৰ ঠিকনাটো মোৰ সাক্ষত দিয়া মতে হয়। মোৰ বৰ্তমান বয়স 41 বছৰ হয়। মোৰ ককা দেউতাৰ নাম স্বৰ্গীয় মজিদ। মোৰ দেউতা এবছৰ মান থাকোঁতে মোৰ ককা দেউতাৰ মৃত্যু হয়। মোৰ ককা আইতাৰ নাম মনত নাই। তেওঁ কেতিয়া ঢুকাল মই নাজানো। মোৰ দেউতা আজিৰ পৰা 16 বছৰ আগতে ঢুকায়। মোৰ বয়স প্ৰায় 30 বছৰ থাকোঁতে মোৰ দেউতাৰ মৃত্যু হয়। মোৰ মাৰ নাম ছফিয়া খাতুন। মুছম্মদ ছফিয়া খাতুন। মোৰ মাৰ বৰ্তমান বয়স 60 বছৰ হ'ব আৰু মোৰ বৰমাৰ ছায়াৰান নেছা মৃত। মোৰ বয়স 20 বছৰ থাকোঁতে তেওঁ ঢুকায়। মোৰ দেউতাৰ 3 ককাই ভাই আছিল। 1 নং গোলাম হুছেইন, 2 নম্বৰ স্বৰ্গীয় মইনুদ্দিন আৰু 3 নং স্বৰ্গীয় নুৰুদ্দিন। মোৰ দেউতা আৰু তেওঁৰ ককাই ভাই জীয়াই থাকোঁতে হলুগুৰি পথৰ গাঁৱত বসবাস কৰিছিল। মোৰ ককাই ভাই 5 জন। নাও মাইলত ইদ্ৰিছ আলী 50 বছৰ, ইউছুফ আলী 48 বছৰ, 3 নং ইউছুফ আলী 46 years, and 4 নং মছুমত আসলিমা খাতুন 44 বছৰ 44 years, 5 নং ভাইৰ মাজত মই অৰ্থাৎ অখিল আলী 41 বছৰ আৰু মোৰ তলৰ সৰু ভাইৰ নাম ইয়াছিন আলী অপচৰ ভেলুপুথি পথাৰ গাঁৱত মোৰ ককা দেউতাৰ দিনৰ পৰা আছো। Now this part is important. ভেলুপুৰি পথাৰ গাঁৱত মোৰ ককা দেউতাৰ দিনৰ পৰা আছো। Exhibit 1 1966 ভোটাৰ লিষ্ট সিৰিয়েল নম্বৰ 21 মোৰ দেউতাৰ নাম ইয়াত মোৰ নিজৰ মা বা বৰমাৰ নাম উল্লেখ নাই। So the 1961 voter list, my lord, 66 voter list, page 17. Here, according to the petitioner, this Ambula Khatun is her mother, but in cross she has clearly said that my mother name is not listed and enlisted in 1966 voter list. Secondly, my lord, in Exhibit 2, 1970 voter list, yet serial number 19 মোৰ দেউতাৰ নাম আছে। ইয়াত মোৰ মা অথবা মোৰ বৰমাৰ নাম উল্লেখ নাই। Here also she has clearly said mother's name is not enlisted in the voter list. But again in 1970 voter list, my lord, page 19, here Anbul Khatun is listed. So this Anbul Khatun is neither her mother, his mother, nor my lord, what is called elder mother. That will be like probably they are trying to say that she is stepmother. So she has said that neither my lord in 1966 নিজৰ মা মোৰ নিজৰ মা বা বৰমাৰ নাম উল্লেখ নাই। In this 97 also 70 also she has stated মোৰ মা অথবা মোৰ বৰমাৰ নাম উল্লেখ নাই। So this Anbul Khatun is nowhere related to her. But my point is that Anbul Khatun is nowhere related to her, neither mother nor mother elder mother. Now in 1997, Exhibit 3, 1997 voter list, yet serial number 1, 152 মোৰ দেউতাৰ নাম, serial number 153 মোৰ নাম, serial number 54 মোৰ মাৰ নাম, 153 মোৰ মাৰ নাম আৰু 153 মোৰ নাম উল্লেখ আছে। This is the voter list where her mother's name is appearing first in 1997. 1970 চনৰ পৰা 1997 চনৰ আগৰ সময়খিনিত ভোটাৰ লিষ্ট বা মোৰ বা আমাৰ পৰিয়ালৰ কাৰোৰে নামত নথকা বাবে কোনো আখ্যা ব্যাখ্যা মোৰ সাক্ষাৎত নাই। So what my submission is that, my lord, he admitted that from 1970 to 1997 there is no voter list of his family, so he could not produce all these documents. So this apparently says, my lord, this Anbul Khatun, the voter list of 1970 and 66 are not related to the petitioner family. My lord, one more thing your lordship will observe. The Mainuddin of 1966 and the 1970, who is son of Majid of Bhelaguri Pathar, and the Mainuddin of 1997 voter list. It is not annexed in the writ petition, but it is in the, my lord, record. It is nowhere, the difference of age is 12 years. My lord, as per this 1966 and 70, he was 55 years in 1970, my lord. This Moinuddin. Moinuddin was in 1970, he was 55 years. Then his date of birth will be sometime in 1925, my lord. 1925. But if we see the 1997, my lord, 97 is shown as 70 years. This Moinuddin, the projected father, is shown as Moinuddin. Moinuddin was 70 years in 1997. Then his date of birth will be something, my lord, 1997.
As per 1966 and 1970, his date of, not date exactly, birth of year is 1915.
Yes,
But as per
1950.
1997 voter list,
it will be 1927.
a difference of 12 years.
12 years. So difference of 12 years in between the this Moinuddin, date of birth, year of birth will be about 12 years of difference. So we cannot say this Moinuddin of 1997 and the Moinuddin of 1966 and 71 is same person. This is not only for this reason only, my lord, first of all, the difference of ages. Secondly, my lord, the lordship may kindly see who are the voters in the 1966 or the relatives in 1966. Along with Moinuddin, one Ghulam Hussain, Anbul Khatun and Nuruddin were there in 1966. And 1970, Ghulam Hussain, Anbul Khatun. Anbul Khatun is shown to be wife of Moinuddin. Now in 1997, who are there, my lord? The Moinuddin, Safia Khatun, who was not there in 1966 voter list. Akil Ali is claiming to be the petitioner, and Aptara Begum and Yasin Ali. No other voters from 1966-70 are available in 1997. That's why, my lord, we generally ask the voter list in between period. Of suppose he has produced the 1970 voter list, thereafter directly 1997. Had the voter list of 1979, 80, or 85 were produced in the tribunal, their name could, if they are of the same family, their name could have been there in the voter list of 1979, 80. But they have not produced. And this is their burden. So in absence of, my lord, others' name in the voter list of 1997, we cannot, and the difference of age in between the, my lord, 1966, 70 and 1997, we cannot say the Moinuddin of 1997 is the same in one person whose name was there in 1966 as Moinuddin. This is the issue, my lord, the petition, the tribunal also opined in the same, my lord, in his opinion, that there are 12 years difference. And before 1997, after 1970 and 1997, there is no documents. And the continuous existence of this Moinuddin. After 70, even though my lord, we accepted this Moinuddin was there in 1970, in his continuous existence in the 1970, from 1970 to 1997 is not true, which is a necessary condition in the my lord 6A of the Citizenship Act. And my lord, the 1997 is the only voter list where the petitioner is showing his relationship with one Moinuddin. Apart from this, my lord, there is no other document. The Gambura certificates were exhibited, those were not looked. Discrepancies of names were trying, my lord, names of the father. And the petitioner is trying to be, my lord, explained by a self-swearing affidavit, which is not evidence in the eye of law. And therefore, my lord, only the point remains, the document remains in 1997. And as I have already said, my lord, the age difference of 1970 and 1997 voter list, age difference of this Moinuddin in 1970 and 1997 is about 12 years. So there is no evidence that this Moinuddin of 1997 and that Moinuddin of 1960, 70 is same in one person. Apart from the, my lord, the voters of the 1970 and 1997 are not similar. No voter of 1997 and 1970 are available in one together, available in. Others voter list are of my lord 2005. This is only Okil Ali and Aptara Begum. So first of all, my lord, the petitioner has to prove that this Moinuddin of 1997 was in existence in India prior to 1970. Then to take the lineage of this petitioner to prove his link with that Moinuddin with a valid documents. So in absence of proper evidence, my lord, that the Moinuddin of 1970 and Moinuddin of 1997 is same in one person, we cannot say, my lord, this 1997 Moinuddin is a citizen of India. And the petitioner, being the son of this Moinuddin of 1997, is also a citizen of India. And it is the failure of the petitioner's part, my lord, to prove that this Moinuddin and that Moinuddin is same in one person, and that this Akil Ali is the son of Moinuddin of 1966 and 70. Apart from this, there is no evidence of only the proceeding. Proceeding himself. The voter list of 1966 and 70 cannot be accepted as the documents of the petitioner, because I have already mentioned, my lord, in cross-examination, he himself said, my mother name is neither my mother's name nor my elder brother's name is available.
Both in 66 and
66 and 70.
70.
So apparently he is taking falsehood, my lord, because in 1966, some Anbul Khatun, who is shown to be one of Moinuddin, is available. And this is not explained who is Anbul Khatun then. So she doesn't know, my lord, that Anbul Khatun was there in 1966. In 1971. The WS, along with the WS, all this evidence is contradictory to my lord WS. In fact, in WS, my lord, she has not probably.
No, it is on record. It is not exhibited. It is not
Yes.
been annexed here. It is on record.
It is on record. Yes, written statement is good. In WS and evidence, he has taken the my lord, evidence in affidavit, he has taken the same step. But in cross, my lord, he has given absolutely my lord, contradictory statement from WS and written statement, or WS and the evidence in affidavit. Because in para 4, the petitioner has stated that the name of the father of the opposite party has been enlisted in the voter list of 1966 under so-and-so Jamunam Kelesi, white part number so-and-so, as Moinuddin, so-and-so. Then para 5, name of the father of the opposite party has also enlisted in the NRC voter list of 1966. The name of the opposite party has been enlisted in the voter list of fathers of the opposite party has been 1970 under 1992 Jamunamo LSC. This is the WS, my lord. The name of the opposite parties and his family members have been enlisted in the voter list of 1997. So, first time, even in WS also, he has stated, my lord, the petitioner and the entire family member's name is appearing first time in the voter list of 1996. Though he has stated that father's name was there in 1966 and 70. The name of the opposite party and the family members of the has been enlisted in the voter list of 2005 under 90 Jamunam Kelesi. Then the name of the opposite party and his family members enlisted in the voter list of 2011. The name of the opposite party has been enlisted in along with wife under the electoral photo identity, person documents. Yes. He has not mentioned anything about his mother, my lord, in the WS.
No, nothing.
Nothing.
Did not name the.
Did not name the mother. My lord. The father name has been taken as Moinuddin, but did not mention about his mother or stepmother, if he has any stepmother. Now in evidence also same, my lord. Only in cross, in fact in cross, also he has admitted this his mother's name is not there in 1966 and 70. So the voter list of 1966 and 71 is not his of his my lord family. He has picked up one Moinuddin of 1966 and 71, and to link himself with that person, he has brought this only to link himself somehow to that person. He has brought these two documents, because not except that Moinuddin, no one is my lord related, because neither in my lord later part of the voter list, neither in the later part of the voter list, the names of other persons of 1966 and 70 are available, along with this Moinuddin and the petitioner. So in absence of those evidence, my lord, the tribunal could not decide that the petitioner is a citizen of India. And rightly, therefore, the tribunal has rejected the claim of the petitioner. Now, my lord, to second issue, my lord, that as I have already said, that my lord, after 1971, though we accept the Moinuddin, it is the one Moinuddin was there in 1970, existence of that Moinuddin in 1997, there is no proof. And that is, my lord, your lordship may kindly see, that is Citizenship Act 6A,
Two
para,
and three.
para 2 and 3 may be referred. It is clearly said, my lord, in para 2. Just I'm reading out the portion of the 6.2, my lord, for your lordship's reference.
6.2 or 6A2?
6.8 to my lord.
Hmm.
Subject to the provision of subsection 6 and 7, all persons of Indian origin who came before 1st day of January, even though who came 1st day of January 1966 to Assam from specified territory, including such those whose names were included in the electoral rolls used for the purpose of general election to the House of People held in 1967, and who have been ordinarily resident in Assam since the date of their entry into Assam, shall be deemed to be citizen of India from 1st day of January 1966. So a person, even though he entered prior to 1966, my lord, and whose name is there in the voter list of 1966, they may be treated as citizen of India, but subject to the condition that who have been ordinary resident in Assam since the date of their entry. So they should be ordinary resident of Assam since the date of their entry into Assam. So this ordinary resident since the date of their entry should be proved. Only saying that I entered in 1966, there is a documents of 1966. Then I produced the voter list of 1997. It does not say, my lord, he is ordinary resident of Assam from 1966 to 1997. In between, he may leave this Assam and he may go back to Pakistan, East Pakistan also, or West Bengal also, my lord, Bangladesh. So here, this fact has to be proved. And this is, my lord, this honorable court has in numbers of cases has decided this point, my lord, that while remanding the matter for my lord registration under 6A3, this honorable court has said, not only you have to prove that you are continuously residing in the state of Assam, that has to be proved in tribunal. Then only you can be registered under the 6A3, my lord. So there is judgment. I've referred the judgment earlier also, my lord, that WPC 8779 of 2018.
Eight, seven.
My lord, WPC 8779 of 2018. Monduti Nondi and others versus Union of India. 19. Nine. There it is, my lord. The provision is there. It is.
Okay.
There, my lord, there provisions. Another judgment, my lord, your lordship may kindly see, that is WPC 2370/2023. That is with regard to, my lord, the claim of the petitioner that he is my father. Someone whose name is enlisted in 1966 and 71, and claiming that that person is my father, that has to be proved by conclusive evidence, my lord. 2370/2023, my lord. Yes, ma'am. They are in para 14, my lord, 2370/23, Aziz Miyama. In para 14, it is said, my lord, my lord, may I read the para 14, my lord. We are constrained to observe that a mere claim by a suspected person by referring to a voter list, claiming a person therein to be his father, is not a conclusive proof, and that by doing so, the person has discharged the burden that he is not a foreigner. This is because there is also a further requirement to prove that the person who is reflected in the voter list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with further materials acceptable in law. So here is the case, my lord, in this case, the petitioner is claiming that the Moinuddin of 1966 and 71 is his father. To claim that, my lord, he has to substantiate further evidence to prove that that Moinuddin is actually his father. But that is not done here in this case, man.
Anything else?
So, my lord, other documents, the two Gamra certificates were there, those were not
proved.
proved. So those are not related at all. So under this, my lord, circumstances, the tribunal has committed no error apparent. My lord, further, my submission will be, my lord, as I have already read out the judgment of the certiorari jurisdiction, my lord. It's clear that certiorari jurisdiction cannot, no, under certiorari jurisdiction, your lordship may not interfere this kind of opinion, because they have not alleged even, my lord, there is any, my lord, alleged any, my lord, injustice or any, my lord, error apparent on the face of the record. Nor they have, my lord, alleged that the tribunal has exceeded his jurisdiction or has not admitted the admittable evidence, my lord.
Okay.
So this is my summary.
Ms. Rajida, want to reply?
My lord, only the age discrepancy is not a ground of this, my lord. Reject this case, my lord. Age is, my lord, it is wrongly recorded in this temporarily enumerated, my lord. That is not petitioner is written, my lord. Are all
No,
this
there is,
in the-
Mr. Paying, where is the judgment?
Yes, my lord,
That-
there is.
When it depends or relies on a particular document, it has to be considered in whole.
Yes, my lord, I have that judgment.
What's it? No, in fact, see, in the case of the student,
Yes, my lord, that has to be,
in this, which Mr. Paying read, the judgment of the apex court,
yes, ma'am.
Central Council for Research in Ayurvedic Sciences. There also, it is very specifically mentioned, relying on a decision of Syed Yaqub of the earlier decided by the apex
Yes,
court.
yes, ma'am.
There, if you see,
Hmm.
where the apex court observed that sorcery would also not lie to correct mere errors of fact,
Yes,
even though such errors may be apparent on the face of the records,
yes,
right? So to correct that fact, because sorcery will not do that thing, that has to be there before the tribunal itself. So if there is a judgment, what is specifically mentioned that depends upon the document, that document has to be accepted in all. There is a judgment.
yes, my lord,
Mr.
that
Payne,
2018 1 GLT 372, my lord. 2018 1 GLT 372. So this,
is it?
yes, ma'am. Basiran Bibi, my lord. Hmm? This WPC. WPC 1002 of 2016. ma'am.
Kindly read that para
It's
30.
Para 30, my lord. My lord, Reliance placed in the case of Abdul Mattali, alias Matlab Muhammad Supra, can be of no assistance to the petitioner in as much as it has already been clarified by this court in previous decision, that the said decision does not lay down any law and was decision confined to the facts and circumstances of that case. Regarding discrepancies in the voter list, which the petitioner contend that were not her creation, being entered into by official election commission, and therefore should not be used adversely against the petitioner. Such contention is without any substance. The voter lists were adduced as evidence by the petitioner herself to prove her case that she was not a foreigner but a citizen of India. Petitioner cannot insist that only that portions of the voter list which are in favor should be accepted, and those portions going against her should be overlooked. This is not how a document put forward as a piece of evidence should be examined. The document has to be appreciated as a whole. So, Malad did the same is also, my lord, relied on later on also. This is 107 WPC 1073 of 2016, my lord. WPC 1073 2016. That same thing was, para 20, same thing was, my lord,
Para,
para 20, my lord, 20. The same thing is accepted, my lord. Para 30 of the. Here also the age discrepancy was there, my lord, in this case.
reiterated the. previous
Rated the same, it's rated the same provision.
Basir and Bibi.
Based on this case. Here also, my lord, the discrepancies of age were there.
Okay.
Now, one more aspect, as your lordship has earlier also pointed out in this case, my lord, the petitioner in cross-examination has clearly said, when his father was 1 year old, the grandfather died. But even then, my lord, the petitioner has said he has, my lord, uncles.
Discrepancies are there. Those are
Discrepancies.
factual
Yes,
discrepancies.
factual discrepancies are there.
Yes, Mr. Ajit. This you read that the age of the procedure's father. Anything else?
No.
Heard Miss L. Wazida, learned counsel appearing for the petition. And Mr. Deepak. Sending counsel from department for the response numbers 2, 3, 6, and 7. As well as the government department, Assam. For the respondent numbers 4 and 5. Also peruse the records of FT case number FT/P/01/2015. Wherein the learned Furnace Tribunal Nagaon, number 10 at the Boca was the impugned judgment in order dated 29/12/2015, holding the petitioner to be a foreigner under the Foreigners Act. Nineteen 46, were illegally entered the Treaty of India in Jacket, Assam, on or after 25/03/1970, without any legal order either. Positive. Any other matter ready? Because we have single bench. My brother has some more matters, that's why.
No.
Any other matter ready? Other matters will be taken up. Yes, Miss Devi, you are sitting, Miss Devi, you are sitting since morning.
Yes, I did it for 10 lordship.
Regarding matter, I think. Purukhi dinner, Thursday hearing. This will come on Thursday. October কৰিলে February ৰিপৰ্ট কিমান হ'ব মই কম আমি পাব্লিক এটা আমি যেটো ইন্টাৰপ্ৰেট কৰি আছে এইটা মেটাৰ বৃহস্পতি এইটোৰ পৰা খালি 12 নম্বৰটো একজন 12 নম্বৰটো 8 9 10 11 আৰু 30 Let us see the case record. Is there? Okay. Let me just go to the record. Please take your seat, Mr. Buru. No. Like, pardon. Just a minute, just wait. Mr. P.P. Burua, learned counsel appearing for the petitioners, and Mr. M.P. Goswami, learned additional public prosecutor appearing for the state. By this application under section 438 CRPC, the petitioners have prayed for their pre-arrest bail in special within bracket NDPS bracket close case number 34/2023 arising under sections 22 within bracket C/29 of the Narcotic Drugs and Psychotropic Substances Act in 1985 arising out of Badarpur Police Station Badarpur Police Station case number 97/2023 apprehending their arrest, and they said NDPS case, or I said special NDPS case. Placing the FIR of the case, it is to be noted herein that the petitioners earlier approached this court for their pre-arrest bail in said Badarpur PS case number 197/2023 corresponding to GR case under the registered under section 22 within bracket C/29 of the NDPS Act corresponding to GR number 821/2023 now registered as special NDPS case number such and such. By filing an anticipatory bail application being 1946/2023, and the court, after perusal of the case diary, by order dated 22/06/2023, rejected such prayers of the petitioners for their pre-arrest bail in said Badarpur PS case number 97/2023. This is petitioner's second pre-arrest bail. This is petitioner's second pre-arrest bail application in said Badarpur PS case number 97/2023 special NDPS case number such and such. Placing the FIR of the case dated 09/04/2023, it is submitted that the informant in the FIR, in the said FIR, dated 08/04/2023, it is like in the informant in its written complaint dated 08/04/2023 before the officer in charge of Badarpur Police Station, informant 849/94/2023, clearly stated that the concerned police personnel arrived at Borof Kul, BOROF, B capital, Kol, KOL, K capital, dash, Digirpar, DIGIR, PAR, area by a private Bolero vehicle bearing registration number AS01 BF 5609, driven by one Dilwar Hussain, at 10:20 p.m. on 08/04/2023. And as such, the Dilwar Hussain cannot be an accused in the case. Second contention of the petitioners for their bail in said Badarpur PS case number, or ID number 2, is that nothing was recovered from their possession so as to name them as an accused persons under section such and such under the NDPS Act. Mr. Goswami, an additional public prosecutor, placed the case there in original before the court. It reveals that on 09/04/2023, complainant Sub-Inspector Bijoy Goswami lodged an FIR to the effect that on 08/04/2023, on a specific information received from reliable source that illegal narcotic contraband dealing is to be done at Digirpar Borofpol area under Borofpur police station. After registering as a GD entry, the officer in charge of Badarpur police station authorized said SI Bijoy Goswami for inquiry and conduct search and seizure as well as arrest in connection to NDPS matter. On reaching the spot, it was found that the two FIR named accused persons, namely Dilwar Hussain and Gulzar Hussain, were carrying bags and were ready for dealing. But noticing police personnel, they managed to escape by throwing away their bags. On search of those bags thrown by the accused persons, suspected YABA, all capital, tablet were recovered, weighing around 2.6 kgs. During investigation, it has been revealed that the accused persons were absconding since the commission of the crime, despite several house searches, and the accused persons till date are evading arrest. The CDR analysis of the accused persons, CDR analysis of the mobile numbers of the accused persons with regard to the relevant towers on 08/04/2023 from 15:24 hours to 01:08 hours of 09/04/2023, it is found that the accused persons were at Digirpar area, and after 01:08 AM, after such seizure of the bags thrown away by the accused persons, the accused persons switch off their mobiles, remaining away from any contacts. Further, Similarly, further. Location of further, the tower location, CDR report will also reveals another mobile of the accused persons on 08/04/2023 at 21:35 hours shown their presence at Bundashil, and since 22:19 hours of 08/04/23 they were shown at Digirpar area. At Digirpar. And according to the case diary, that corroborates the presence of the accused persons at Digirpar during the commission of offense on the night of 08/04/2023. Case diary also reveals that the FSL report of the seized suspected Yaba tablets recovered from the bags thrown by the accused persons that each tablet weighing 0.1 gram per tablet gave positive test for methamphetamine. The FIR, the case diary reflects that the accused persons, Dilwar Hussain, Hussain, alias Kuti, Kuti, son of late Matholo Bur Rahman, is resident of Borof Kol, Digirpar under Badurpur Police Station of Karimganj District, Assam, and Gulzar Hussain, alias Fetu, is also son of late Matholobar Rahman of said Borof Kul Digirpar area, Digirpar, under Badurpur Police Station of Karimganj District. It is not the case of the petitioner, that petitioner. The FIR name accused, Dilwar Hussain, was driving the private Bolero vehicle in which the complainant, along with other police personnel, reached the area of occurrence. Case diary reveals sufficient incriminating materials with regard to the involvement of the accused persons in the case, as the independent witnesses in their statements clearly stated they saw the accused person noticing police personnel thrown the bags from where the Yaba tablets were recovered in their presence. Considering such material, the court is of the view that it is not a fit case to grant pre-arrest bail to the petitioners for their involvement in the alleged crime. Accordingly, this pre-arrest bail application stems of the petitioners, namely such as in said such and such case number, special NDPS case number such and such, stems rejected. Return the case that here.